Hey guys, sorry about the late. Yeah, I'm late and sober. It's those darn children. My the mom guilt is strong today because I had to kind of surrender the fact that today is a bad day, so I will not be doing birthday cake because usually I make birthday cakes and my oldest son really wanted this kind of I make a cake that looks like a bowl of spaghetti. Yeah, mom got guilt is, big this morning because I had to do a store-bought, cake, and, our local Walmart is not as I think I figured it out, but if I'm still muted, let me know. Of course I am. Yeah, it it is what it is today. I see Cat Lady is back with her red, outfit and poofy hair. Yesterday, it looked like she had combed it and put it back, so she must be having the same kind of fried eye I am. I have the sound booster. I know, what kind of evil, hateful people don't go live every day like they have, family and such? Just terrible, just terrible. Let's get started. I believe they will be going through, jury instructions, and then we will have to suffer through Bates twice, which Yeah, I am late and sober, but not muted anymore. So let's see about jury instructions, and then we have some dirt on, Miss Kathy Bates here because she may or may not have had to sign a similar resign or fire order for shenanigans that she did. We will be doing kind of coverage of that during verdict watch. So let's see here. Well, I'm trying to get to a point. Oh, okay. We are seeing them just flipping through papers. It's very fascinating. See if I get to the point where they're talking, because 'cause I'm sure Kathy's gonna have I don't know. I don't know. I honestly and we don't know who Barney Gumble is. It's it's a bit, I feel like I need to know who everyone is. No, we did not. I don't know if this is just the population of the town that is either yet to be sentenced, yet to be tried, or simply there for they're the totality of the residents that are not incarcerated at the moment. Hey, guys. Hey, everyone. And we are still going. So they're supposed to be going over the jury instructions.
From
Right.
the jury. I did forward to counsel
You guys, I think his
by
hair looks
email yesterday
better-ish.
afternoon the proposed jury instructions. I understand you would have an alternative instruction as it relates to 1014, Ms. Isherwood. Is that correct?
Yes, Your Honor, in the proposed 1014, when you get to the elements of the crime, there is
No,
nothing about provocation in it.
but I did ask, because I did run for my HOA and did promise that if I should win, although I did none of the peopling, I was going to walk into Team America's, theme song with, red, white, and blue leggings when I could still wear leggings and maybe sparklers, because America and democracy, even though we're not a democracy, but
And while we're giving them a provocation instruction, nowhere in the instruction does it tell them what to do with that. what I proposed has, and this is from a trial that actually went in Ashland County. And they have as the element, which I believe is appropriate, and I'm just looking for it.
Morning, everyone.
They have the provocation language in the element. He either was not allowed to use or threatened.
Listen, Salvador, I'm looking at you know, if Bill gets acquitted, maybe he can put me in touch with, you know, how to raise Nile crocodiles and I can have a moat. I live on a hill. I'm just saying. There's nothing in the HOA, you know, bylaws against a moat with gators. I know, Jim, you are looking fire.
In self-defense due to provocation, or did not actually believe that the force used was necessary. And I think that's very important. As they get down to the final question, they're going to be applying the elements. And if provocation isn't in the elements, I think it would cause undue confusion. They're going to have that instruction on provocation and what they are to consider, but they aren't going to be told what they're allowed to do with it. Because it does affect their final verdict, or it could.
Mr. Hogan?
Your Honor, I think the way that the court provided the instructions is appropriate, because the provocation in, I think that would have been 810 or 815, doesn't really indicate how to include it within the elements. It just indicates also read this if provocation is an issue. So my concern is that in the jury instructions as listed, it does not, the standard instruction doesn't indicate that you should include the provocation language in the elements. So I think that the way that the court has it listed and noted is appropriate.
Well, you will note that
You guys, I have the
provocation
okay,
language
sorry. I had the
is
thingamajig on, but I didn't
incorporated
clicky
in
it, so
privileged
that was a my bad.
self-defense
Hopefully you can hear it a little better.
instruction immediately after retreat. And the way I have prepared the instructions,
Hi, Billy.
quite frankly, I think that the language you are proposing, Ms. Ishwood, may further confuse a jury. All of a sudden, within your proposed instruction, it's talking about a completely
Sorry,
different
guys. I
criminal
thought I
offense, disorderly conduct.
did it correctly, but
which
I didn't use the
the
little
jury hasn't heard a
button
word
thing.
about.
You know, Your Honor, I just gave you the Ashland County instruction. I did not draft it for this case. I just did a statewide inquiry last.
This woman put into look, this woman internet's like I internet. Dear Google, please give me blank. And she took blank off the internet. Ma'am, you was supposed to be a lawyer. Don't make me go pre-legal to you know, don't make me go to paralegal school to school you, ma'am.
Night, and Ashland County sent me this instruction. I'm just looking at the elements of intentional homicide within this instruction. Not, it talks about a different defendant and a different victim in this case. I sent it as is, frankly, because of lack of time. I mean, I could take this instruction and draft it. What I'm concerned about is the elements of the crime. The elements of first-degree intentional homicide that caused the death of Riley Menente Powell. Cause means the defendant's act was a substantial factor in producing the death. The defendant acted with intent to kill Riley Menente Powell, and the defendant either was not allowed to use or threaten force in self-defense due to provocation, or did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. That's the line I'm concerned about, the element. And in the element that we got in the proposed jury instruction, it just says the defendant did not actually believe that the force used was necessary. That completely leaves out all provocation language for the jury to consider when they're actually looking at the elements of the crime and coming to a decision.
Except within the provocation portion that the court submitted, it says you should also consider whether the defendant provoked the attack. A person who engages in unlawful conduct of a type likely to provoke others to attack and who does provoke an attack is not allowed to use or threaten force in self-defense against the attack. I think that's an accurate statement of the provocation law. And so I'll note your objection, but as it relates to the 1014 and call it 805, 810, 815
Yeah,
instructions, I'm going to give them that.
look, I'm very sorry, and in my mother's heart, my heart goes out to Tiffany in whatever capacity she can feel it because of her, method acting. She did lose a child, and I would never wanna be in that position, but, yeah, but this entire thing should have been ruled self-defense in my humble opinion as not a lawyer, and this Kathy Bates is just ugh.
Prepared. Any other objections from the state?
Well, Your Honor, then I just want to note, then you're saying that that's the law, then I can tell them if they find it was provoked and the defendant did not do that, that they should find him not, or they should find him guilty.
You can make your argument consistent with the law, always.
Right. But because it's not listed as an element, I just foresee confusion, and the state's entitled to a fair trial as well here.
Absolutely.
So you guys, Murph's Turf is an awesome superstar, and she sent me a bunch of stuff that indicates that Miss Kathy Bates may have been given a similar "you walk now or you're fired" kind of thing for some very shady shenanigans. So we will get into that during verdict
Absolutely.
watch.
You can certainly discuss the provocation and whether that eliminates the possibility of self-defense. But also, as I think everyone's aware, that even if there is the provocation, that does not eliminate the self-defense depending upon recovery of that right. So
That's not in the substantive instruction.
that's not in the substantive, but it's implicit in the 805, 810, and 815 instruction. So other than that, any objections from the state?
No, Your Honor.
Ms. Hogan, any objection from the defense?
Just one with respect to 482 and the verdicts, as was addressed in a previous motion in limine, we'd be asking that the reading start off the first reading of "we, the jury, find the defendant William C. Zielinski not guilty," and that the not guilty verdict be the first verdict submitted because he's presumed to be not guilty. That was a previous motion in limine that we addressed that the court had granted.
And I think at that time, we were anticipating a simple guilty, not guilty verdict on a sole count of first-degree intentional homicide. That would not be applicable in this case because
The more I hear him, the more he sounds like kind of mopey, Snuffleupagus, like, "Oh, Big Bird, I was just having a bad day." Because Cookie Monster is kinda hyped. He's like, "I love cookies," all the time. So it is, he's more of a snuffleupagus to me, but he can still be our Cookie Monster.
Because the self-defense, the issue of possible second degree
Yes.
homicide requires an evaluation of the first guilty or not guilty, well, guilty, excuse me, on first degree intentional homicide. Then if that's not found, then they review the second degree. And then if that's not found, that's where we reach not guilty, I believe. So I'm going to give 482 as printed. Any other objections from anyone?
No.
And
Yeah.
will counsel be ready to?
David, I was defending my argument that to me, the judge, while Cookie Monster-esque in appearance, his voice reminds me more of Snuffleupagus. Because Cookie Monster is always pretty hyped and wanting, well, now fresh fruits for some reason and kale because he's become demonic. So to me, he's in looks, he's Judge Cookie Monster, but in voice, he's Judge Snuffleupagus.
Go straight to closing after I stop the instruction, or do you need some time to set up exhibits, or?
I've already set mine up.
I should be ready to go after the state.
Okay,
So I just asked the bailiff to, well, I can move the easel now. I don't want the jurors not to be able to see you.
I think they can, and it's just as well if they don't.
Oh, no, definitely not that easy.
Aw. Hearts Judge Snuffleupagus Cookie Monster.
Is this okay for security?
I think we said we'd start at 10, so I think we just need to wait a few minutes.
All right, then I'm going to.
Did I say 9? I meant 10. I meant to say 9. Thank you. Yeah, I was thinking.
I can definitely, if you guys put in the Discord thing, that way I can do that. You guys, this is a work in progress. So I am working on this whole YouTube life balance and YouTube research balance and all sorts of the Twitters and the Photoshops. So I would be glad to look at that. And then, yes, I believe for the next thing, I'm going to kind of take a back seat because doing a trial takes a lot of time actually, which is, not shocking. But I'm going to take kind of the sidekick role and let Salvador do Edgecomb. I might do a short trial or something. I'm not quite sure yet. I say I'm not going to stream, but you guys know I'm kind of addicted to both learning how to stream and also doing other things. So we are waiting for. Okay, thank goodness. I thought I was gonna be super late and okay, I thought we were gonna start at 9, but apparently 9 is 9:05. It's getting ready to start fairly soon, so. Oh, this clock is killing me. All right.
Case, it says he or she in it, and,
Is she trying to
Honestly, should be he if we missed that one.
right, and, you should also consider whether, William Zelensky provoked the attack. That would be my proposed change.
I thought they just got done with proposed changes. Did this woman not read this last night, not look for typos, and then suddenly found one? Well, John Gary, when we get, I don't know if you were here when I release this, but Murph's Turf has sent me the reason that this particular ADA resigned under the cone of shame, if you will. and it is pretty spicy, and she was pretty slimy, allegedly. Same, me too. I have to remember that that's. Oh no.
And then in the second paragraph, if the attack which follows caused William Zelinski to reasonably believe he. The other ones were made to fit the case, so I think that would be appropriate.
First, let's talk about the he and she. I don't see any, oh, in the provocation second paragraph. All right. I will read it as he. I will just read it as he's.
That's what I plan to do
All right,
after
and
we
then
get
you want
done with the closing statements and we start verdict watch.
Well, I think everyone knows who the defendant is. If you wanted to see, while we were off the record, counsel pointed out that I'd missed including 460. Here's the 460 for your packets. But I will read the provocation as he. I'm not going to modify the ones that are printed. The jury can figure out we're talking about he. He's the only one who's claiming self-defense and the only one that would be relevant to. And so you're asking that rather than referencing him as the defendant, that I put his name in?
I would, just because I plan on displaying it, and I want it to be exactly as you read it.
And have you prepared an exhibit that shows his name rather than defendant?
Well, we haven't printed it yet.
Then I'm just going to, rather, now we're past 9, I want to get the jury in. So I'm going to read it as printed. They know who the defendant is here.
Yeah, they did ask to start deliberating after the first witness. I'm not confident about the tap water in
Okay,
this
and
town.
so in your packets, I'm inserting 460, obviously before 482 and immediately after closing arguments of counsel. That's when I'll be taking a break to allow you to make your closing arguments. Anything else we need to talk about before we bring the jury in?
No.
You guys, the judge's hair is looking, I mean, it still looks really fake, but it's looking better today. All right, guys, here's what we're going to do. I can continue to let the jury instructions play, and you guys can listen to those, and I can comment, in between, or I can monitor the jury instructions on my screen, and we can bring up some of the tea about what happened with the Kathy Bates woman. All right, I'll give you guys a couple minutes to percolate on that, and we can listen to Cookie Monster.
Well, ladies and gentlemen of the jury, I want to truly thank you for your
Never mind.
attention and your promptness.
This voice is going to make me go to sleep. I'm executive ordering. I am making an executive decision. So let me pull this up because Miss Kathy Bates may have some issues of her own that she is, really quick to say, well, he was either fired or or resigned or he would be fired. Okay, so report on Isherwood released. Investigation finds she acted in an appropriate manner and ethically. We'll be the judge of that. Let me take my banner off or my doodad that David made. Okay. The sheriff's grievances against former district attorney Veronica Isherwood were without merit because the government investigated itself and found itself innocent. According to an independent investigation by the Owatamie, don't come at me, or Wisconsiners, no, County District Attorney's Office, Assistant District Attorney Randall Schneider released the results of his investigation on the report December 15th, 2022. Yeah, you guys, maybe it's just me, but if little candy cane Ty is the one that investigated her, I still think she did some shady stuff, allegedly. Schneider's investigation or investigated Ishwood in response to a request by Waukapa County Sheriff Tim Wiltz and Chief Deputy Carl Arts to the state's Attorney General on June 21st, 2022. The letter alleges that the sheriff believes a review by DCI, Division of Criminal Investigations, would be biased and DCI would most likely cover up the district attorney and state liability. Um, Probably. Veris dictum. I hope I did not just curse and I don't know Latin as much as I want to. The DCI investigated Waukapa County Sheriff's Office last year, but the results have yet to be disclosed to the public. I love how all these reports happen and we never get results. Like we're never going to know what happened in Las Vegas. Altered report. The conflict over how Isherwood responded to charges that Detective Captain Julie Thobeson made in a report sent to the DA's office. According to the Outagamie County investigation, a deputy who made a traffic stop called Thobeson for guidance on searching a vehicle. The deputy put language in his report about the search and information provided to him by investigative captain. When the report was later reviewed, a Waukapa County detective identified issues related to the search and brought them to the attention of the investigative captain. Ah, Salvador, you are my hero, because chat is my hero, because you guys, our collective powers mean that I can keep this production going for the most part. The investigative captain reviewed the report and did not agree with the language the deputy used. The captain changed the language of the deputy's report to better suit how she believed she directed the deputy to conduct an inventory of the vehicle, the report says. So there are many, apparently, police reports that were getting altered to make searches look more legally less dubious. According to Snyder's report, she threw the original report in the shred bin. 2 detectives removed the original report from the shred bin and gave it to Isherwood. The sheriff's office later disciplined them for insubordination. Thoben allegedly altered the police report without consulting the deputy and without notifying the district attorney. It was determined that the investigative captain routinely made changes to reports without informing the district attorney, according to Snyder's investigation. Wiltz asked the Outagamie County Sheriff's Council to conduct an investigation, which found no malfeasance on the part of the Waukapa County Sheriff's Office. Y'all, this is why people like me maybe have tinfoil hats sometimes. You guys investigated yourselves, even though there's clear misconduct, and you're like, well, it wasn't that terrible. However, the actions of the investigative captain clearly violate the sheriff's own report writing policy, Schneider said, noting that the policy forbids report changes or alterations by anyone. No, they're doing so right now. Judge Snuffleupagus is doing jury's instruction. So we are going over why it might have been Miss Kathy Bates was kind of, like, you can resign or we can, you know, let fire you. Also, Miss Cat Lady decided that she was, going to ask for some random law from another county, but that would work, you know, for the jury instructions. Yes. Okay, so you guys, what I'm doing is, right now the judge is giving jury instructions. Looks like the state got nothing of what they wanted in because, Kathy Bates did, like, a last minute Google search in, like, law.net and found one particular wording of, you know, intentional homicide that she liked much better, but, yeah, she tried all sorts of shenanigans, and the judge was like, "No, I'm pretty sure that, accepting, a couple of typo errors, we're going to keep things as I wrote them." And the defense attorney asked that, the verdict form have not guilty first, but I guess it has the highest, charge going down to innocent, and the judge is like, "We're not gonna put innocent first." So he's been kind of making sure everyone's following the rules, and Kathy Bates is not exactly, liking that she's not getting all of her stuff, and we are now going over, why it might be that Miss Isherwood was asked to leave, the DA office. There, have been several reports of police officers, their, higher ups altering police reports to better serve the district attorney or make it less legally dubious. Now, they've all investigated themselves and found themselves super serial innocent because this is the, sort of ending report that, has cleared everyone, but there was talk of rampant police report changes that the DA knew about. So I will pull up more of that information because they were awesome. There's just a lot of stuff that we have been doing here lately. I've got to get to the thing that I was doing. One day I'll be super all on top of it. Not probably today, but someday. However, the actions of the investigative captain clearly violate the sheriff's own report writing policy, Schneider said. According to that, the policy forbids the report changes and alterations. Morning. We are going over yes. I'm barely yeah. It's it's a hard thing, and someday I will learn the so basically, the policy forbids anyone but the officer who wrote the report from changing that report. Um, the judge finds a Brady violation. Isherwood informed the judges and defense attorneys on the Waukapa County Sheriff's Office at the Waukapa County Sheriff's Office was altering the officer's original reports before submitting them to her office. She knew nothing about this, of course. All the side eye. During the February 21 hearing, Huber said he was inclined to find to this particular judge, said he was inclined to find the sheriff's office as as a whole from the sheriff down was involved in a Brady violation. He did not single out any individual officers. In criminal proceedings, the Brady rule requires prosecutors and law enforcement to disclose any evidence that could benefit the defendant. The informant or the information that Thobin removed from the report was evidence of a warrantless search. Attestation clauses. Because she had evidence that the sheriff's office was altering the original reports, Isherwood made changes to the attestation clause of criminal complaints involving the sheriff's office. She has a like I'm sorry letter that she had to send out to a bunch of different defense attorneys. At the beginning of the narrative portion of the criminal complaints, there is a clause that attests to the reliability of the report and records that underlie the charges. Here is a typical attestation clause in a criminal complaint. Your complainant is an officer with the Wakapa Police Department. Your complainant makes this complaint upon information and belief and upon reports and records of that department. Yeah. Let me see if I can pull it up. Murph sent it to me and it is only, let's see. I will pull that up next because I think I can open it in aha. Yeah, I will pull that up next. Murph's turf is just awesome. Your complainant has relied upon these records in the past and found them to be truthful and reliable. Here, so it- here's an attestation clause in a criminal case involving the Wakapa County Sheriff's Office. Your complainant is an officer with the Wakapa County Sheriff's Office. Your complainant makes this complaint upon information and belief and upon reports and records of that department. Your complainant is aware that the reporting officer, Detective Sergeant Traeger's reports were not reviewed by any administrative staff or any other officer before submission to the Wakapa County District Attorney's Office. Your complainant believes that Detective Sergeant Traeger prepared his report in compliance with Wakapa County Sheriff's Policy 322. So, yes, I believe promoted, definitely. After this change was instituted, the sheriff's office refused to cooperate with it, according to Schneider's report. The chief deputy signed 80 complaints and later testified under oath that he had not read the complaints or the attestation clause. On May 9th, 2022, email to Isherwood, Wiltz asserts that having to sign the complaints with a revised attestation clause violates my fundamental separations of power and infringes upon the Wakapa County Sheriff's Office constitutional and statutory authority. Yeah, yeah, she did. Although I think it was maybe a dual helpfulness thing. I don't buy for one moment that she was unaware that things were going super shifty. I mean, I will do that when I'm not, so I'm simultaneously listening to the, court or the jury instructions and reading. So I will do look, y'all, we are just aiming for purgatory around here. But let me see if I can so this basically goes on to so Isherwood let's go to the juicy bits. So, former Waukapa County District Attorney Veronica Isherwood believes that she has been vindicated by the Outagamie County District Attorney's investigation of her conduct. Okay. I knew from the very beginning I did everything I had to do to go by Wisconsin law and legal ethics. Right. Isherwood and Sheriff Tim Wiltz have been at odd ever since Isherwood began questioning him about altered police reports. The conflict became public during a February 21, 2022 hearing when defense attorney Kate Fridge Dury asked Wiltz to tell her over the phone that the district attorney was sticking her nose where it didn't belong. He replied, "Correct." Yeah, it's almost like he's setting me up. I can set myself up for my own self. Yeah, I have a hard time believing that the district attorney who works almost hand in glove with, you know, the sheriff's department in a small county, you know, didn't know that things were being shenaniganized. On February 24th, Isherwood sent a letter to 79 area defense attorneys indicating that the sheriff's office had altered a report resulting in the removal of exculpatory evidence. If Julie Thobin had just followed the sheriff's policy and the chief deputy had just read the criminal complaints that he had signed, none of this would have happened. Isherwood said. Isherwood resigned as district attorney effective December 17th, 2021. So, okay, it was not 20. Yeah, she is all the shadies. Let's see. She said Wilt's attorney had informed her that his clients was Waukapa County, which included the county's human resource director, corporation counsel, and county board members. Isherwood accused the county of trying to get rid of me just because the sheriff disagreed with me. She said she has plans to remain as the assistant district attorney through 2023 to help her replacement. Moving forward, I plan to work with the sheriff to ensure that sheriff staff are following their own policy regarding report writing and forge a productive path forward, said Kat Turner, Waukapa County's new district attorney. I am sure that you are doing that, ma'am. Very, very sure. So let's stop the screen and then present her I am sorry letter. And let me see if I can get this in invigorated. All right. So if I blow it up, you're not going to be able to read it. Well, I'm not going to be able to read it. So you guys can sort of see the letter, and I am going to read it if I can, because it is super small. All right, here. I am going to get this if it kills me, which is very likely to. You have no idea, you guys. Okay. Well, I cannot read it as of this moment because it will not blow up and continue to give me But here, let's see. You are receiving this letter because you represent a defendant who has been charged with a crime in Wakaba County after an investigation by the Wakaba County Sheriff's Office. Based upon state's obligation to disclose potentially exculpatory evidence, um, as set forth in Brady versus Maryland, uh, I can't read the name there, but another person versus Maryland. I am hereby advising that the state is aware and is in possession of certain evidence which indicates that Wakapa County Sheriff's Captain Julie Thorbison altered a report authored by a deputy in which resulted in the removal of exculpatory information. Captain Thobin testified that her actions this week. Furthermore, Sheriff Tim Willis testified on Monday, February 2020 or 20 February 22, 2022, that this practice is done regularly at the sheriff's department. It was also disclosed that evidence of any charges were not preserved or any changes were not preserved. We have no idea if the reports in the case you are defending were changed or altered in any way. There is only one case we are certain the report was changed, but the sworn testimony that has there's sworn testimony that this happens regularly is very concerning. Under normal circumstances, you would receive our notification of a Brady violation only when it affected the I can't read it. It's way too small. My eyes are not good. So we are going to jump back to let me see if I can pull up something else. Okay, so this is the original report where, she's not faking it. I know. Thank you, Murphs. Turf. I will finish reading this letter because it was super small. The attorneys at the Wakapa County District Attorney's Office believe that under this circumstance, the Brady Gigolo, I want to say gigolo, but that's not right, makes it incumbent upon us to notify you that this is of this irregularity. Additionally, we have received information that the reports to my office of these irregularities were discouraged. We pride ourselves on upholding an extremely high ethical standard in our charging decisions and prosecution of criminal cases. The loss of someone's liberty is a tremendous responsibility that we do not take lightly. The courts have been notified of this information. We want to make sure you are aware so that you can have appropriate discussion with your client prior and during the determination of whether to proceed to a plea and or sentencing. And then I have the initial article that is all of the spices. Yeah, yeah. Tell me again how you didn't know exactly what the heck was happening. Okay, so this was from March 4th, 2022. Over the last week, low-level Class F felony burglary case from 2020 in Wakapa County has unraveled into the re-examination of dozens of convictions by the district attorney's office after it was revealed that the sheriff's department regularly alters reports in ways that could be harmful to defendants. The fallouts from the revelations are is still unclear as defense attorneys and the state public defender's office are only beginning to assess how widespread the alterations are. Among the charges that appear to have been made are instances of adding probable cause to a report to justify a search after the fact and deleting exculpatory evidence. Yeah, she was totally unaware. It just snuck up on her. It's hard to know how many reports were changed because the department did not keep record of those changes. It's rattling, if not earth shattering. It's a big deal, local defense attorney Tom Johnson says. The prosecution of many cases is dependent upon the contents of the sheriff's report. Let me see if we're done with him doing the, oh, yeah, Kathy Bates is about to start. Damn it. I mean, yay. The sooner we get done with her, the sooner we don't have to hear from her again. All right, guys, here we go. Pray for us now and at the hour of Kathy Batesness.
I set this up. 977 days ago, he lost his life. He lost his life when Bill Zielinski put a shotgun, double-barreled, in his armpit and pulled the trigger. Dr. Kovacs testified that the shotgun blast at that close range caused Riley's death, tore open the bottom of his heart, his aorta. Dr. Kovacs opined that he had maybe 10 or 15 seconds of
Opined. Swear to God, we should have made a bingo card. All of the words being opine.
life after that blast. We know Bill Zielinski pulled the trigger and shot Riley. He called 911 and he said, Riley Menente was walking home. I confronted him. He came at me and I shot him. Throughout the investigation, he claimed it was self-defense, except that Riley Menente Powell did not have a gun. He did not have a knife.
She's
He did
gone
not have
full binger.
a baseball bat. He had no weapons on him. He was walking home. Bill said he was walking home from the jail where he had been transported because he owed money on a New London fine, municipal court. An intentional homicide requires that the defendant cause the death with the intent to kill. But if you listen to the judge's instructions, it doesn't mean that on the morning of October 19th, Bill intended to kill Riley. I don't believe that. I don't think any of you believe that. It doesn't mean that when he drove to Mill Street or was started to drive to Mill Street, that he thought, I'm going to go to Mill Street and kill Riley Menente Powell. Of course not. But as the judge instructed you, that intent to kill can be formed in an instant. And I submit to you that when you pull the trigger of a double-barreled 12-gauge shotgun, which you've already pulled back the hammers, that is intent to kill. It's also an instruction.
To be fair, Wild Bill did have a pickaxe, though.
That intent to kill is the mental purpose to take the life or was aware that his conduct was practically certain to cause the death. Anybody experienced in firearms, you don't have to be experienced in firearms to know that if you put a shotgun against the person and press into them downward and pull the trigger, that it's practically certain they're going to die. Now that's the information we knew back on October 19th, 2020, 977 days ago. As of June 19th, 2023, at the beginning of this trial, he wants you to believe that pulling the trigger was an accident. It was Riley's fault. He didn't tell the dispatcher it was an accident. He didn't tell Tiffany Powell it was an accident, Riley's own mother. He didn't tell Tara Dalrymple it was an accident when she was at the scene screaming, "Why did you do this?" In fact, he said, "He came at me. I had no choice." Does that sound like an accident? 977 days later, it's an accident. But it wasn't an accident on October 19th, 2020. He didn't tell any of the officers who arrived on scene that it was an accident. He didn't tell Officer Wasrud, Shabilsky, Deputy Thorpe. He told no one until this week. He had 977 days to come up with the accident scenario. That was 977 days that Riley didn't have. Now, he testified yesterday on how he was terrified of Riley. But he also testified about all of his police training, that once or twice a month he'd come across hostile subjects. He talked about how he was learned to de-escalate situations. He learned how to control a subject, how to place somebody under arrest. So when it's convenient for him, he draws on this police training that at the time he hadn't used in over 15 years when he was separated.
It does seem as though she's pulling a mega binger, but Judge seems to be okay with it. And look, y'all, I have to pause every so often, just so even though Law and Cuck is covered, I don't want it. I really dislike this woman, though.
From the city of Wapaka. But when it's not convenient for him, all thoughts of his police training go out the window. He told you that it was self-defense because he was so terrified of Riley. He told you that he turned down Van Street because he had to go tell Tara not to give a ride. All he talked about to everyone was that I need to get the animals back. I need to make sure they're safe. We saw a lot about the timeline that was being prepared here.
Her is big mad she didn't think about it.
Please wait. And very familiar with this timeline after this week. But I made an addition to this timeline. Something, can you do it? That's better.
Your Honor, may we approach?
Sure.
David, if you are free to come on, you can explain the legal stuff. As of right now, I think she's just a heifer who done try to steal R. Scott Baio's beautiful, beautiful timeline. Yeah, you guys, all of the cursey words for this woman. No, what I think the defense is trying to do is perhaps like what they did in the here, I'll let her finish. Well, I don't know if he's going to say something. Oh, I guess the jury's going out. Oh my gosh, David. You need to come on. Any lawyerly person, Nicholas, if I send you a thing, the effing juries, she done messed up our beautiful Scott Baio's timeline with her bitchy typing. I'm not sure, but looks like they are sending the effing jury out for, or closing statements. Come on, Nicholas, I'll send. Wait, Nicholas, aren't you on your own Dolbert hearing? Yeah, I'm only pre-law, so I have no idea.
We are on the record outside the presence of the jury. Mr. Hogan, I take it you're objecting. It says Bill learns location of reptiles.
Specifically, the objection is to the 10:15 and 28 seconds PM. That was not testified to at all.
Your Honor, that's math. There was testimony at 10:17:45. Bill's call with Danielle ends. We played the call. At the moment that on the call, they gave the address of the reptiles. The testimony was there was 2
red
minutes
handwriting
and
or
17
typing. She couldn't even be
seconds
bothered
left
to
on
write.
that phone call. 2 minutes and 17 seconds subtracted from 10:17:45.
So basically, this entire trial, the defense has been doing a demonstrative where he is writing down a timeline of basically how to showing the timeline of events, because in cases like these in Wisconsin, I think it's statutorily required to make it seem like Bill had hours to think of his attack. And what the defense attorney has been doing is, as testimony is coming in, as the reports are proving this beautiful timeline, let me send you a link. I thought I did, but it's very possible that I did not. So I sent you a link, Uber, but I'll send you another one. So during the trial, yeah, she's arguing that she mathed this particular edition. It very well is, John Kerry. I think, in my very humble opinion, what the defense is trying to do is, all right, we need your hello. This doesn't happen often, does it?
Well, so it sounds like she's adding evidence that wasn't testified to into a demonstrative evidence. So, first of all, it looks like that demonstrative evidence was actually admitted. So, she's trying
Yeah.
to then alter it later on
It's
after it was
almost like
already
altering
admitted.
reports is kind of a thing for her.
Yeah, I mean, it was kind of how do I say this on your channel? A mean thing to do, a disingenuous thing to do. And then, but more importantly, from the legal standpoint, she's attempting to enter a time that wasn't ever mentioned in the evidence. Remember, demonstrative
Yes.
is used to organize the evidence that has been admitted. And so if she's putting stuff on there that hasn't been admitted, then that's a problem.
All right. We are going back to listen to Kathy Bates trying to explain how she's going to mess up my lovely timeline
10:15:28.
with her bitchy
It's
font.
math.
You can't
Mr.
math
Hogan.
evidence.
You're right. My recollection of the testimony was when that phone call started and the time in which on the recording there was. I don't recall any testimony of anybody indicating a particular amount of time left in the phone call.
That was the purpose of that testimony, was to identify the exact time that
Might have been the purpose, but it didn't happen, did it, lady?
It was the purpose of the phone call that we played. And
Yeah, she
at
had
the
one of her
time that,
questions about
Mr.
the
Salachi stopped the recording,
timeline yesterday
we put into
stricken.
the record how much time was left. It was for exactly this purpose. I know I didn't do the math, but I don't believe math is a fact that can't be presented. In fact, I have my slip here where I was going.
This is argument. I'm going to allow it, and you're certainly free to argue. That's not what the evidence is. You know, it's an interpretation of evidence. So I'm going to allow it.
All right. Well, he's going to allow it.
Well, I mean, it is argument, but for her to put it on there, I mean, the defense should definitely be arguing back like this wasn't a fact.
Yeah, hopefully. She's using lawyer math too. This ish knows she can't math. Hell, I know I can't math.
All right, you got me driving around for the rest of the time while I'm doing my chores, but I'll be on.
Okay, well, I'm trying not to talk when they're talking, at least for closing and pausing. But
no, that sounds good. You guys can see me doing my shopping.
Ooh.
Please be seated. You may proceed.
Thank you, Your Honor. So as I was saying, at 10:15 and 28, or 10:15 and 28 seconds is when Bill and Tiffany learned the location of the reptiles. And where does that number come from? We played that call. And if you recall, we stopped as soon as she gave the address out on Highway 10. And the second that she ended it, that she said the address, we had 2 minutes and 17 seconds left on that call. On Mr. Hogan's exhibit, we know that the call ended at 10:17:45. 10:17:45 minus 2 minutes and 17 seconds is 10:15. So because we're using this timeline throughout this trial, Bill parked in front of Tara's house at 10:17 and 26 seconds. Van Street is 400 feet long. He had almost 2 full minutes where he's driving down School Street that he knew where the location of the animals were. He knew exactly where they were. And everything he told you is that's what is most important. Now, this week, he wants you to believe that after seeing Riley walking, he turned down Van Street because he had to tell Tara, make sure you don't give him a ride. One of the discussions you're going to have when you go back into the jury room is what if his testimony is reasonable? To say that he would stop, and not only stop, but park out on the road instead of just driving in next to her door, hopping out saying, don't give Riley a ride, hop back in and go get your animals. No, he's going to park out on the street when he just saw Riley. He's going to park out on the street and he's going to walk down her driveway because he said the door they use is at the back. And he told you the reason for that was he was afraid he was going to get parked in. At 10:17 at night, Monday night, school night, he's afraid.
Y'all, cause crackheads and method actors generally keep school night hours. They're like, no, sir, no, ma'am, I can't do my meth right now because it's 10 o'clock on a Wednesday.
Yeah, her story just has a lot of. No, I was just gonna say her story has a lot of assumptions that don't necessarily have to be presented in the trial, right? Or weren't presented in the trial. She's just telling her story. That's what a typical prosecutor does. That's what she's doing.
Yeah, I'm hoping they gave them time limits because I can only handle so much of this woman.
75 minutes, right? Or was that a different case?
That sounds right, but
Well, at that point, if you're that desperate for your animals, drive across the lawn. He's afraid he's going to get parked in, so he parks on the street. And now he tells you, or then he told you, that he saw Riley running around the corner from School Street onto Van Street. And again, 400 feet long, 6 houses. Terrace house is on here. We also have the house with the Ring camera, and we have the brick.
is it a cargo van or a Jeep, if you can safely answer?
I saw that. I'm not answering. There's a question out there about what vehicle I drive. I will say that I'm not currently driving my normal vehicle.
Okay. Well, then for the safety and for his, online OnlyFans, to not be to keep the mystery alive, we
Yeah,
will
we
go
got to
back
keep it
to
alive.
testimony.
Goes house. We know those houses. Somewhere in the area
I
of
know,
the,
that's
of the
upsetting.
video starting, I believe it was somewhere back here. I couldn't see the stick figure he wrote, but he saw Riley running. Now, Bill testified he had gotten out of his car and was walking up Tara's driveway to tell her, don't give Riley a ride. And he saw Riley running down the street at him, shouting, I'm going to get you, you MF. I'm going to beat your ass. And that caused him such terror that he went back down the driveway to his car, grabbed a stun gun, grabbed a double-barreled shotgun, opened the double-barreled shotgun, loaded it, closed it, and pulled the hammers back, which is essentially taking off any safety. Ready to fire. Common sense, logic. If Riley's running down this road and he sees him even a third of the way down the road, though he said he saw him at the corner, but the picture the defense put up, it was pitch black. Even if he saw him at the corner, by the time Bill got back, could hear what Riley was supposedly yelling at him, loaded his gun, and then met Riley. He met him right in front of the house with the doorbell camera. So all of this takes place right out here. Riley would have been at the car long before he ever got a gun out. And how do we explain that on the doorbell cam, Riley's standing there? Now the timing that makes sense is that Riley's walking down the street and he sees his mother and her boyfriend pull down the road. And all the testimony is Riley spends a lot of time with his mother and Bill. He's been in their car. They had already confronted him about the thefts and he was offended, but he said he didn't steal. There's no indication that he was afraid of Bill. So he's walking down the street. And the evidence is, according to Google Maps, it takes about 2 minutes to walk down the street. So where would he be after a minute? Bill parks in front of Tara's house at 10:17, and they're arguing at 10:18. 1 minute and 4 seconds. So what happened in that 1 minute and 4 seconds? I can guarantee you if Riley was running full blast, he would have been at the car. He wouldn't have only been halfway down the street. But if he was walking, he would have been halfway down the street. He's going to see what his mom and Bill are up to. Perfectly reasonable. And now Bill wants you to say that he was allowed to use self-defense because Riley was yelling at him that he was going to beat his ass. And that caused him such terror that he believed he was going to die. Because as the judge read the instructions, the only way he gets to use deadly force is if he believes he is going to die. And there has to be an unlawful interference with Bill. So as Riley's walking down the street, what unlawful interference? You know where the unlawful interference is on Riley. He's walking down the street. You see him stop. You see Bill and Tiffany come to him, not the other way around. Bill comes to him. And you know, when I think about this,
Ma'am, I super duper hate you.
case,
Well, that's the way to put it.
after hearing the testimony,
I'm sorry, but she is.
You weren't here to pause it earlier. I wanted to say, she's like, according to Google Maps, it takes 2 minutes to walk. Well, first of all, he was running supposedly, but secondly, Google Maps is not the most accurate with the walking times, because I feel like it incorporates the time of an elderly woman with a walker and or a wheelchair.
So it's at Mo speed, not past Mo, but current Mo.
Yeah.
Yeah, I just.
did Tiffany know that the hammers were pulled back? Did Tiffany know when she lifted the gun and it was pointed at her son's head that the slightest pull on one of those triggers and he would have been dead?
Madam, you prosecuted Tiffany for pointing the weapon at her son, regardless of if she knew it was a deadly weapon or not.
Yeah, and I was going to say, don't throw out reasonable doubt into your case. Is it possible?
Well,
Is it possible? Those are bad words to be using for a prosecutor.
She doesn't seem to be a good one, but that's allegedly.
Anybody, common sense, gun safety, you don't run around with a double-barreled shotgun with the hammers pulled back.
You do when you're
That's intent.
when you're getting
In
attacked.
fear of your life.
This woman is killing me, David.
There's the only evidence that there was an unlawful interference on Bill is his self-serving testimony this week.
I got to jump
He
off.
had
I'll be back.
977
Okay,
days
bye.
to come up with. Riley runs away from Bill. And when you talk about self-defense, don't forget that Riley had the right to defend himself. Just because he's the 18-year-old kid and it's the adult who has the gun doesn't mean he doesn't have the right to defend himself.
We are going to go over this again, but when you are 18, you are a kidult. And Riley seemed to be more kidult than normal, which means you have the body of an adult in my mind, but the mental capacity of a pissed off toddler who just gets what he wants because he's having a bad old tantrum day. So he's not a kid, he's a kidult, and he was a douche at that one. Not to speak ill of the dead.
The judge talked to you about provocation. And as he starts to read it, it gets pretty confusing. So I wanted to pull that up. I believe Bill Zielinski provoked any attack.
Madam, you couldn't even use a goddamn highlighter? How lazy the hell are you?
Riley did on Bill. Riley is standing on the street, according to the doorbell video. Bill confronts him. Bill told the 911 operator he confronted him. Bill confronted him and is trying to get him with the taser. Now remember Rowan? Rowan told you that before Bill left the house on East Road, he said, I'm going to tase and handcuff Riley. So while Bill tells you his biggest concern was the animals, I think his biggest concern was taking Riley into custody, because during that whole week, he was acting as a cop. He was investigating the crime. It was going to be solved on the street.
Madam, we have evidence that your sheriff's department sucks balls. Maybe he knew that there was something rotten in Denmark and wanted to do his own investigation because
he was interviewing people. He was emailing and texting everybody he knew to be on the lookout. And that night, he decided he was going to arrest Riley. That's what the evidence is. That's what shows on the video. Except he's not a law enforcement officer. He was separated from the force 15 years earlier. He didn't have training, and he didn't have the right. He did not have the right to handcuff Riley. He did not have the right to attack him and tase him. He did not have the right to point a firearm at him, much less pull the trigger and kill him. He did not have that right. In the confrontation, Riley never armed himself. All those weapons, that's how Bill drove around Wapaka, with all those weapons in the car. But we heard from Detective Rodans where those weapons were. There was another gun in the trunk. We saw Riley didn't go in the trunk. There were knives in the back seat, baseball bat in the back seat. Whatever this garden tool is, in the back seat.
it's a pickaxe, ma'am. Pickaxe,
hammer.
ma'am. If I can Google, you can Google. It's a beautiful thing.
Riley went to the door of the car. He didn't get in. And as you saw, there weren't weapons within reach. And Bill was right there watching him. And Bill took the gun back from Tiffany. Now remember, he testified the hammers were pulled back. If the attack, which follows Bill's provocation, attacking Riley, if for some reason after that, Bill reasonably believed that he was in imminent danger of death or great bodily harm, he may lawfully act in self-defense. But the person may not use or threaten force intended or likely to cause death unless he has exhausted every other reasonable means to escape. And that's
That wins
Bill
the internet, John
has
Gary.
to exhaust every other reasonable means of escape. What means did he have? Well, he could have driven away. The car was running, the doors were open. He could have just driven away. He told you he was afraid the car would stall. Anybody who's driven a stick shift, what happens if the car stalls? You start it up again. You close the windows, you lock the doors. What's going to happen to him in the car? What could unarmed Riley do?
Ma'am, have you not seen any of the protest things where they, block in a car? If you're on certain chemicals, maybe you start beating the car. Maybe you pick up something off the side of the road. Maybe you jump in front of it.
To him if he's in the car? And if it stalls, just start it again. He could have run to Tara's house. He could have just honked the horn. If he just honked the horn and stayed on the horn, that would have gotten the attention of every neighbor. He could have locked the gun in the car. His fear was that Riley was going to get the gun from him and use it on him. And he said, I knew I'd be dead. Well, lock the gun in the car, because Riley wanting to punch him in the face is not a reason to shoot him. It is not a reason to kill him. And Riley saying, 18-year-old kid, put the gun down and fight like a man. Sounds like an 18-year-old kid. An 18-year-old kid who says, put the gun down and fight like a man, that causes a former police officer such terror that he has to.
I am not sure, but all of it. She is look, if I didn't have to pick up my oldest daughter, I would be drinking, and I might give that responsibility to my husband because her rebuttal is going to probably kill me.
Shoot him? That he has to have a loaded gun with the hammers pulled back, ready to fire? It's absurd. There was just about a minute between the end of the video that showed the confrontation and the 911 call. So we don't know what happened in that minute. Tiffany said Riley never grabbed the gun. But you know what? It was pressed onto his skin. And you know what? If he grabbed the gun and tried to get it away from him, he has that right. He absolutely has that right. He has the right not to die. And think about Bill's.
They wouldn't let her touch any sort of weapon anymore because she lit up the entire jury box, the courtroom, and the judge.
Explanation of the shooting and how it was Riley's fault. Well, for one, he's experienced in firearms. You don't put your finger in the trigger. He did it because he was so terrified. Because Riley was trying to get the gun from him, he put his finger in the trigger. Well, if you're going back and forth, guess what? You're going to pull the trigger. That doesn't make it Riley's fault. But when you think about the wound that's almost under his armpit. Melissa, close your eyes, please. It is almost to his armpit.
What the hell was that? I'm sorry, but I've never seen a prosecutor, tell a family member not to look. I mean, maybe it's something that she does as a matter of, process that she does. And I'm trying not to pause it, but I do need to, kind of stop it once in a while. Also, Snooky Bump is back, and I am glad that she is sticking with the trend. She has lovely hair and a respectable, low bump up in the back.
And as I'm going to take it off now. It's off. His armpit. Riley's pulling the gun in there with two hands. One on the foregrip, one on the barrel, conveniently where DNA was found. Yeah, I believe, but this is what you would do. You wouldn't go like this. That makes no sense whatsoever. And he would have had to been leaning in because it was a downward trajectory. Bill and Riley are the same height. So he would have had to been down and leaning in. The gun would have had to been elevated. Two hands on it. That story makes no sense. We don't know what happened, but we know that didn't happen.
Come on, Scott
He
Baio.
would go like this. Bill motioned on the stand that he was going like this. But that makes no sense.
Yes, so where she has her hands are approximately where the DNA of Riley was found. Now you can sort of exclude the trigger guard, or not the barrel guard, because it was pretty close to his skin. But where he had it, she's lining herself up awkwardly to make her story fit. The way that the defense attorney used his demonstrative correctly, it showed much more a plausible struggle, not what she's trying to show. Again, I am pausing for copyright issues.
Because it's nowhere near there. Bill's story makes no sense. Timing is so far off. The fact that he was terrified for his life because
Oh, hell to the gnaw. She is not making fun of my timeline. Indigo, we're about to take these beautiful, cute little earrings off. She is about to test my soul.
Riley yelled, "I want to beat your ass." And then he tried to tell you why he was so terrified of Riley. Now, we acknowledge there was a domestic incident in February.
I'm not
And if
touching-
everybody who has a domestic incident in Wapaka County could be hunted down with a shotgun,
Okay, well, it's the purge, y'all.
we'd have much lower population.
Holy
They're not
shit.
good, but they happen. But to think that a domestic incident in February means that Bill
He also threatened to go, to the streets with his mother.
Zelensky is terrified of Riley in October, and every other incident that Bill talked about was Bill's own testimony. But he did testify Riley had never hit him, ever. They did verbal sparring. 18-year-old, I'm going to get you. Big man.
There are no words. I try not to actively hate or dislike anyone, but this woman will be in my prayers, and my prayers will be as such. Dear God, allow her prosecutorial excellence be greatly needed in Guam. Your humble servant, Mo. Immediately.
Probably didn't like Bill. Probably would have wished his mother wasn't his girlfriend. Right? Never testified Riley said he was going to kill him. Never testified that there was anything that would have caused him such terror. And you remember when he was talking to Officer Wazru downtown? And he's talking about, the fight they had before the animals disappeared. No fear. There was no fear in his voice whatsoever. Wouldn't that be the time that it would have shown? Wouldn't it have shown in the 911 call? See, there again, he wants you to believe his police training made him so calm that he could just say, Riley was walking home, I confronted.
Oh, even Scott Baio's like, the hell are you saying, lady? The words that are coming out of your mouth do not make sense. Please stick to the English we all agreed on, ma'am.
Him, he came at me and I shot him. He doesn't say he tried to grab the gun from me. Nope, he came at me and I shot him. Calm. Tiffany's calm. The one you hear is Tara, who's hysterical. The father of her grandchild is laying there and no one's helping him. And let's talk about police training. CPR, stop the bleeding, roll him over and see if he's alive.
I'm sorry, what precluded any of the other people from doing that? I mean, I understand Bill could have done it, but what precluded his mother, Tara, who's being hysterical, any one of the other 1,900, I'm sure, hangers-on they had at that house, because it was probably a flop house? Allegedly. I mean, what precluded anyone else from going to render aid?
Nothing. Not a thing. Not a bit of aid was rendered to that poor boy. And now they want you to rule, to judge his actions and his statements and say it was all reasonable. His terror was reasonable. Well, there was no sign of that terror 977 days ago. Not a sign. Not till this week. The judge gave you instructions on credibility of witnesses. Do they have a reason to lie? Well, does he have a reason to lie? He shot someone in cold blood and killed him. Does he have a reason to lie?
Bill, just keep your face, keep it lower
Mariah
capped.
Brickle
I will do all the
testified
caps,
when
okay?
she was looking out
Sweet
the window,
baby.
she heard, "Stop or I'll shoot you." And then pow. That is an intentional homicide. That is not an accident. That is not self-defense. That is an intentional homicide. And to think that it was Riley who said that makes no sense. Riley never had a gun. The person with the gun was Bill Zielinski. Stop or I'll shoot you. And he did. And at the end of your deliberations, I'm asking you to
I
find Bill
dislike her.
Zielinski guilty of first-degree intentional homicide in taking the life of an 18-year-old boy. Thank you.
Ms. Hogan.
Y'all, this woman's making me want to take up like Virginia Slims. Swear to goodness. Come on, Scott Baio, let's go. I believe in you.
Accidents happen. Crimes are committed. We all know Bill didn't commit a crime that night. We know.
I get it. Look, Riley needs to have, everyone deserves justice, regardless, because they're human. But she is doing it in such a, if she would do it in an honest way, I wouldn't have an issue. It's the fact that she's doing it in such a disingenuous, dishonest way. If she truly believes that he shot Riley in cold blood, it was hello.
Hello, hello. Can you hear me okay?
Yeah, now you're in a boat. I'm just
Now I'm
super
in a
jealous.
boat.
Y'all, we knew it. You are really the what is it? You can now claim to be a marine lawyer.
Maritime
Or
lawyer.
admiralty.
Yes, that's right.
What'd
I miss?
Well, let's see. She went full Krause, did a little like, well, he was a 19-year-old just saying, I want to fight you. And sure, there's domestic abusers and he had a domestic assault, record. But if we allowed people to shoot every domestic violence offender in this county, we'd have a lot less population. True words, paraphrasing just a bit.
Okay. Salvador says I'm muted. Am I muted or is he just messing with me?
He's being Salvador. I can hear you.
Okay, good.
But cardinal among all sins is that she done tried to kill the beautiful, beautiful timeline with some red bitchy typing. So now it's defense attorney Chad to deal with it because she's making. Again, my main thesis is that if she truly believed that this is the charge that she should go with, operate straight and on the facts. Don't do these greasy things. Don't just go with the law.
Well, John Gary, too, makes a good point. I think they might have been better off going with straight justification for self-defense as opposed to an accident. They kind of are bringing a hybrid. Like he was justified in having a gun there, having it loaded, having it cocked, but then at the end of the day, it was an accident. So,
yeah, kind of like the Kim Potter. And I don't think that worked as well.
No, it didn't. Yeah, I think picking one or the other would have been better.
Yeah, that's John Gary, you make a good point. Yes, we always have tacit agreements. And Dennis Heaton asked if you're going to go see the Titan debris.
No, I got to put my boat in the water today, so I had to get down here. So I'm streaming mobile today with my mic and everything.
David, you are now my hero. You are officially in a land ship. You can be the honest to God sovereign citizen we all wanted you to be.
That's right. Pretty soon it's going to be a water ship too.
Or a land boat.
I'm going to be on Laid Back News at noon, so I only have a few minutes, but I wanted to pop on.
Okay, well then let's start listening to Scott Baio.
Know from the evidence presented in this case that Bill didn't act with an intent to kill Riley. He didn't act with an intent to hurt Riley. In the moment that Riley was shot, there was a struggle over that gun, and Riley was pulling it away, causing Bill's finger to hit that trigger. It's sad. This is a sad case. The judge is going to read you one more instruction or two. One of the final instructions tells you, base your decision not on sympathy, but on the facts. It's a sad case where an 18-year-old lost his life. We saw so many witnesses through this trial, how they felt when they found out Riley passed away. We saw everyone's reaction trying to talk about what happened that night. Everybody who knew Riley, Bill included. And it wasn't just Bill on the witness stand when he broke down trying to talk about Riley. When Officer Rodens first told Bill, this is the first time Bill is told that Riley didn't make it. You saw his reaction in that video. His face was slightly behind a mask, but you saw those tears in his eyes. You saw him doing this. That's also a man who cared about Riley, who was devastated to find out that Riley didn't make it. Don't be swayed by the sympathy in this case in reaching your verdict. Look at the facts that we all heard. Everybody that you heard through about what Bill was going to do that night talked about Bill wanted the animals. Bill wanted to bring them home safely. Nobody said he only wanted to find the animals. Everybody said he wanted to find them and bring them home safely that night.
It was havoc.
Tara tells you, she testified that when Bill and Tiffany came over, they were asking about the animals. If she'd heard any information about the animals. She even told you that right before Bill and Tiffany leave, Tiffany says, if you see Riley, tell him we're not angry. We just want to get the animals back. Now she tries to tell you that Bill was agitated. And remember what she told you, what made Bill agitated? Daisha showing Bill and Tiffany the Snapchat video and photo. But we heard from Tiffany, we heard from Bill, we heard from Rowan that while they're still at East Road, they received that Snapchat information. That wouldn't have caused Bill to become agitated at Tara's house. It was information he already knew. She said he was calm. When he left, he was calm. Bill knew Riley was involved, but was still calm. All he wanted to know was where the animals were so he could go get them and bring them home safely. When he met with Officer Wazrud testified, Bill was calm. He expressed concern about the animals. He expressed concern that when finding out Riley might be released from jail that night, that Riley could go and move or get rid of or stash the evidence. And Bill would not be able to get them and bring them home safely. April testified that when Bill left, all he wanted to do was find the animals and bring them home safely. Not a single person told you that Bill was so angry, so upset with Riley that he wanted to hurt him, much less kill him. Nobody testified about that. We can see in that timeline that Bill left East Road and shortly into his drive was told, avoid Mill Street.
She doesn't look like
Law
she'd be fun
enforcement's
to
already
hang
on
out with.
scene. Bill knows.
Sorry, what?
I just pop in. I said she doesn't look like she'd be fun to hang out with.
No, she looks like her cats pee in her shoes while she's watching. They just don't like her.
Oh, absolutely.
Or
I
they're
agree.
or they're peeing in her shoes right now. And David, I'm fully with you. I believe this ish needs to be in a full suit. I do not like this athleisure wear.
Yeah, no, right? I mean, that is a fundamental issue I have with female attorneys being allowed to appear in whatever, as long as it looks nice or somewhat they can justify saying, "Oh, well, this is my formal wear."
That is not formal. That is like going to Walmart, not trying to look like a slob wear.
No, Target more. That's Target wear.
True.
Walmart's
And
more
she's wearing. Yeah, never mind. I retract
Hopefully
my
law
statement.
enforcement's going to get some information. So he doesn't go to Mill Street. He hangs out on Main Street for a while. Then he goes to Tara's house. And you saw there's no urgency at that time. He pulls in the driveway behind Tara, drives all the way to the back by her garage, following Tara down that driveway. Because there's no urgency at that point. He's killing some time waiting for the police to let him know some information about where these animals might be. But he's not there long because he gets that phone call from Officer Wazrud to come and meet him on Main Street. Even Tara told you on the stand that when they left, they said, "We'll be back." We know Bill was driving in the direction of Tara's house after he met with Officer Wazrud. We don't know exactly at what point in his drive from Main Street back to Van Street that he did get that phone call from Danielle. But he was driving back to Tara's house. And yes, at some point during that drive, they found out where the animals were. That was part of that priority that night. Bringing them home safely was the other part of his main priority. And so when he sees Riley, he doesn't even know that that's Riley down the road on School Street in the distance. He thinks it could be. So he turns onto Van Street, drives all the way down and parks in front of Tara's house. Because he's going to tell Tara, don't give Riley a ride. If that's Riley and he's going to come over here, don't give him a ride. Because Bill knows, Riley now knows where these animals are. And if he's going to be released from the jail and come get these animals, there's going to be a confrontation at Angela's house. And Angela said to Bill and Tiffany, I don't want any trouble. I don't want the police over here. They were over here earlier. Don't bring any trouble. I don't want any trouble here. So he parks on the road because he is just going to run in and tell Tara not to give Riley a ride. Riley got a ride everywhere. Riley didn't have a driver's license. Riley didn't have a car. He got rides everywhere. From Madison, from Mackenzie, the daughters of Tara, who could be at Tara's house. Tara doesn't know where these animals are. And the state, in cross-examining Bill, said, well, it would be obvious that Tara wouldn't give Riley a ride to Angela's. Why? Tara didn't know the animals were over at Angela's. It wouldn't be all that strange for Riley to come over and ask for a ride. And in closing, the state tried to get you to believe that Bill's testimony was he got out of his car after he parked and he was walking down Tara's driveway. But that's not what Bill told you. Bill told you he got out of his car and started to walk towards Tara's driveway. Didn't even make it to Tara's driveway. And he sees somebody off in the distance running at him. He doesn't know who that is until Riley speaks and is yelling, I'm going to get you. which is the same thing that he told Bill right before Bill's firearms went missing. When Bill saw Riley running down the road at him, threatening him, the state keeps telling you, well, Riley was unarmed. We know Riley was unarmed. He didn't have a weapon on him. Bill believed he could have a weapon because Riley had stolen guns from him. Riley could have other weapons on him. Bill told you, in his experience, if you get brought to the jail and you have weapons, that you're legally allowed to have knives, and you're released, they're going to give them back to you. There's no reason for the police to hold on to your knife if you're going to be released, and you can legally have that knife. So as Riley's charging down the road at Bill on this dark street, Bill has no idea that Riley could be unarmed. He believes Riley is armed. That's why he goes back to his car and he gets that shotgun. Because Riley can be armed, and if Riley has a weapon, he's going to get Bill. Those are Riley's words. And all of the prior experience Bill had with Riley, seeing Riley chase Mackenzie, knowing that he beat up Mackenzie, got into fights at the jail, threatened him, threatened Tiffany.
I think he's doing a pretty good job, guys. What do you think?
Yeah, he's selling a compelling argument. That's my. Again, I didn't watch the whole trial. I'm assuming what he's saying was
yeah,
brought out in the evidence.
Yeah, he's not doing this thing where he's being slimy and kind of alluding to things or making the claim that, a known house of meth would, operate with school hours. God, she annoys the snot out of me. Trying not to curse before 2 hours, it's like, oh, she just super duper just twists my curls.
You're not monetized yet. You're good.
Oh, well, then, trying to be better.
Just days before this incident. That's why Bill grabs his gun. Tiffany had got out of the car, and they're on the road, seeing Riley come at him. He's not walking. Nobody said that Riley was just walking down Van Street. Because where he was when Bill saw him was down School Street. And the state presented evidence that to walk the distance of Van would take 2 minutes, more than 2 minutes if Riley's down School Street. But Riley's there in just over a minute because he's running down School Street, running around the corner, and running directly at Bill.
Oh my goodness.
Even
Thank you guys
Tiffany
so much.
testified to that Riley was running down the road. So he gets the gun in an attempt to stop Riley. The state told you Bill testified when he grabbed that gun, he loaded it and pulled the hammers back. That wasn't Bill's testimony. Bill's testimony was, I don't remember when the hammers were pulled back. He didn't say, I grabbed that gun and I loaded it quick and I pulled the hammers back. No, he didn't do that because he wasn't intending to use that gun. He wasn't intending to shoot Riley. He was intending to stop the threat that was barreling towards him. And the sight of a gun would hopefully stop Riley from advancing towards him. We saw that use of form sheet that the state presented. Simply displaying a firearm is use of force. that can hopefully stop a threat from coming towards you. And so Bill got his shotgun and he approached where Riley was running at him. Hopefully, Riley would stop. And at some point, he did stop on the street, right in front of Joseph Brown's house. And that's where the video starts. But Riley didn't just magically appear standing in one spot. He was running down the street at Bill, and Bill was trying to stop any more advancement coming towards him. And Riley was looking to fight. We heard Riley several times, "Put down the gun and fight me like a man." So when Bill and Riley are close, we see this video. We're going to play it one more time for you. And watch. Riley doesn't have his jacket on. When he takes his jacket off because he wants to fight Bill, Bill told you at that moment, I thought it was unlikely that Riley had any sort of weapon. So what does Bill do at that point? When he now believes Riley may not be armed, he gives Tiffany the gun and gets his taser, because now he knows, now I really don't need to use this gun. I never wanted to use it. I never intended to use it because I don't want to kill Riley. I just want to stop him from coming towards me. So that's why he takes out his taser and attempts to subdue Riley. And it's not until Riley runs to the car. And remember the testimony? Riley's been in Bill's car before. Riley knows all of these weapons are in Bill's car. Knives scattered about his car, in the center console, near the ashtray, in the passenger side area, in the glove box. There's weapons in the back seat. It's not until Riley runs back to the car where he knows there's weapons, Bill knows there's weapons, that Bill gets the gun. But he doesn't go up to Riley and point the gun at Riley, because he can see Riley doesn't grab a weapon. And when Riley gets away from the car and starts coming at Bill, "Put down the gun and fight me like a man," we see that Bill's not pointing the gun at him because he doesn't want to use it. We see Bill backing up, having the gun pointed towards the ground, just like we can see.
Right. Did anyone hear Tiffany say there's stuff in the car? I don't know. Maybe it's just me. I've heard it so many times.
You can back it up a touch. I don't know. I didn't hear it.
Okay. When she's getting hit.
Now, the other important thing that we saw in this case is the positioning right at the end of that video and the beginning of the next. On the left of your screen is the very end screenshot of the video right before the shot rings out. And on the right is the screenshot of the very start of the next video. And I want you to look and I want you to pay attention to where Bill is standing before that gunshot and where Riley is after the gunshot. Bill didn't go towards Riley. Riley came at Bill. Riley came at Bill and the gun went off. Those were Tiffany's words. Riley came at Bill and the gun went off. And we know, even though Tiffany said, I don't think Riley grabbed the gun. She says, I think I saw the gun the whole time. But she even admitted on that stand that when Riley went at Bill, Riley's back was to Bill, or Riley's back was to Tiffany. Tiffany couldn't see his arms. Tiffany couldn't see.
Just to stop a little bit. So again, so Lon Seaward, when I do get monetized and famous, won't come back and steal it from me. Tiffany is a woman who could not keep her IDs because she kept freaking losing them. Like in the throuple, she was apparently the dumb one.
Has this been confirmed to be a throuple?
Yes, apparently, according to Bill, wife was totally okay with them going down to Florida and becoming physical at a reptile expo.
Hey, more power to you, man. Looking like that and getting 2 ladies.
Well, okay, David, one's whose sole occupation is the consumption of non-approved pharmaceuticals and is an unwelcome guest of the state. And then the other one is beige toast on beige. It's never the
Details.
threesome you want to see.
I say that looking at the defense legal assistant, so I don't know.
The gun. Tiffany didn't see what Riley and Bill were doing with the gun because Riley came at Bill, grabbed that gun.
Okay,
and
all
tried
right,
to
I
pull
get
it
it
away
now.
from Bill. The state wants you to believe that it's absurd or it doesn't make sense that Riley would have been reaching for the gun and pulling it when it went off. But we saw that. We saw with a gun that Officer Rodens told you had the same measurements as the shotgun used in this case. And this blue tape is the...
So this is the demonstrative I really liked of his. It's the exact measurements of the weapon in question. And the blue parts are where they found the decedent's DNA.
Ooh, I like that. I like that. So he marked it where the victim's hands were and the defendant's hands were. He's not really a victim. If he was,
Well,
he's the
yeah.
perpetrator. If he's actually, if it's self-defense, right? So we'll say the other guy's hands and the defendant's hands.
Yeah, this was one because as you saw Kathy Bates pimp frog hole because she's not allowed to handle even fake weapons. She's doing it all wonky and it doesn't make sense. With that, I'm making my non-professional opinion, but that particular demonstrative is going to get Bill acquitted, in my opinion.
Okay, cool.
Because if it makes sense to me, and I have a hard time visualizing different things spatially, and in a brawl and or tussle, it's hard to figure out what's going on. That clears it up for me. I can visualize with that.
Lefty's right. So in the scenario that's being painted by the defendant is the victim. And that is true. And that's why I think in Rittenhouse, they weren't allowed to refer to any of the dead guys as victims. That was actually an appropriate ruling by the judge, right? You know, that's why everyone's giving him, not to be on a tangent, everyone's giving Schroeder crap for Zachariah Anderson, but he was a decent judge in Rittenhouse.
Yeah, as a person who's not watched, again, for the bajillionth time, the Anderson trial, I will probably be looking at that next, maybe, if I want to take on another heavy case.
You should rewatch it.
Well, that's what I'm going to do, a rewatch, probably. I just don't know at what time, because doing trials is kind of hard. But I'm addicted now, so But for me, that's what I don't even remember where I was. Sorry, guys. It's been a Friday already.
Exact location where the foregrip was on the shotgun, and this blue tape was exactly where the flashlight was. And when we had Dr. Kovac on the stand, he told you if somebody's leaning forward and pulling the gun, that this position is consistent with the injuries that Riley had. Because this is moderately downward, it's front to back, and left to right. It's the exact trajectory of the BBs. That's what Dr. Kovac told you.
I gotta run.
The
Sorry.
state wants you to believe that Riley was on his knees with his hands up in the air when Bill shot.
Oh my sir, would you like to accompany me to the pettyverse? Because I should have my petty patch, but sir, that was the best sort of snarky, and we love it here.
In that video that we saw, we know that the shooting happens and Bill is able to get the phone and speak to 911 in an exact minute after that video ends. As Riley's trying to come towards Bill saying, put down the gun and fight me like a man. And the state wants you to believe that Riley went up to Bill, said, okay, Bill, I give up. That's what the state wants you to believe. Because that's the only other way that Riley gets the injuries that Dr. Kovac told you about. That doesn't make sense.
The facts, not in evidence.
We're arguing.
Okay.
This argument, proceed.
In her opening statement, the state
Suck on it,
told you
lady.
the gun was in a downward trajectory. And imagine the positions of the body that it would have to be in. There's no other way Riley gets those injuries with that trajectory unless he's either on his knees or grabbing the gun and pulling it towards himself. Which one is consistent with that video that we saw? We know that that's what happened because it's consistent with the neighbors, Mariah and Nathaniel Bricko. The only people that you heard in this case that have no connection to Riley, except the officers and the experts. All the other citizen witnesses that you heard from have some sort of connection to Bill or Riley, but not the Brickos. And what did Nate Bricko tell you? That he looked out, he turned on the light, and we even saw in those screenshots, it was a little bit lighter because that was the Bricko's front porch light that came on. And he says when he looked out, he saw what he initially described as a struggle. He then said, well, maybe it wasn't a struggle, but they were definitely close. It looked like they were touching. Because from his distance, seeing Riley and Bill struggling over that weapon and pulling it, that's what he saw. That's the struggle that he was describing in his written statement. And Mariah told you in her written statement that she heard very clearly, I'm going to shoot you if you don't stop. If Bill intended to kill Riley, why is he saying that? He's saying that because Riley came up to him, grabbed the gun, they're struggling, and Bill said, if you don't stop, I'm going to shoot you. That's what Mariah said she heard very clearly. And right when Nate saw that struggle and they heard a mention of a shooting, Nate said he immediately turned, went inside, grabbed his son, and under a minute later, he heard a muffled gunshot. Because that was Riley pulling the gun into himself, causing the gun to go off. Those are the only witnesses that don't have a connection to Riley or Bill. They can be believed. Other injuries are consistent with Riley pulling the gun away from Bill, causing it to go off. Remember the state introduced evidence of Bill's finger and how Dr. Kovac told you that that would happen? If Bill's finger isn't, or if the butt of the gun isn't against Bill's shoulder and the gun kicks back and it hits your finger, that's what could cause the injury to Bill's finger. Just like when Riley reached, grabbed it, and was pulling it, the butt of the shotgun came away from Bill's body, causing his finger to hit that trigger, discharging the gun, causing the trigger guard to go back onto Bill's finger. There's no other way that Bill's finger gets injured in that way. Also consider, if Riley is on his knees when he gets shot, we saw the image of Riley forward. But if he's straight up and down and gets shot, and the force of that shot, where is Riley going to go? He's going to go this way. But that's not what we saw. Because Dr. Kovac told you if Riley grabbed the gun, pulled it, got shot, he could fall straight down. Just in the exact position that we saw. It's consistent with the DNA evidence. How does Riley's DNA get on that foregrip unless he grabs it? His DNA is located in that mixture with the highest likelihood ratio that the state laboratory has. Rarer than the entire world's population. 1 in 7 trillion. We know that's Riley's DNA on that foregrip because there was so much of that DNA when he grabbed it and was trying to pull the gun away from Bill. Kevin Scott told you that when there's friction and pressure applied, that's when you're going to leave more DNA behind, as Riley did when he grabbed it and was trying to pull it. Why doesn't Bill assist Riley? Bill told you he thought Riley was still a threat. Tara told you when she came running outside, she saw Riley on his knees with no blood. She thought Riley was faking it. She didn't think Riley had actually been shot. She thought Riley was faking it. And if she thought Riley was faking it, what about Bill? This is a person who just said, put down the gun, fight me like a man, came at Bill and grabbed that gun. If he gets up, he's still a threat to Bill. So Bill does what he believes to be the best. Get that phone, call 911, and get them there as soon as possible, which is exactly what he does. Yes, Bill did not try to render aid to Riley. As the state just pointed out in their close, and you heard Dr. Kovac tell you, that wouldn't have saved Riley's life. It wouldn't. Don't think that the failure to run over to Riley and try to render aid means that Bill's guilty of intending to kill Riley.
You know, that's actually a really good point he brings up because in an argument I wouldn't have thought of as far as, you know, the fact that had he even rendered aid, there would still be an issue. I mean, he's making it plausible. He is making it very relatable, but he's also sewing up that bit of, gosh, maybe if I'm a juror, I'm like, well, he said it was an accident and then he didn't, rush over to give aid. So i- if I'm a juror, that has been something that's been kind of, he's not required to render aid, but it's nice and a good thing that I think that the defense attorney, who I know he has a real name, but he will always be Scott Baio in my heart.
Bill did exactly what you would expect if he did believe Riley was a threat, to still maintain some distance from him and talk to 911. Officers told you, not just Bill, other officers told you that the number one priority when they respond to a situation like this is to secure the scene. Because if there's still an active threat, you're not going to be able to perform aid if there's still a threat for an attack on officers or others. That wasn't just Bill who told you that. That was officers. Current police officers told you, number one, always make sure the scene is secure. And if Riley's still a threat to Bill, it's not secure. Remember, we heard from Officer Shabelsky. He told you that this was the second day on his own. He was not even 3 months into being a sworn police officer with Wapaka Police Department. Had just got done with field training officers. This was his second shift on his own. His first emergency call he ever responded to on his second day on his own. And what did Officer Shabelsky do? He remained calm. Because he told you why that's so important for people to remain calm, to provide details, to make sure officers know of the information they need so that rescue can come, additional officers can respond. Bill remained calm because that's what he was trained to do. Just like every other officer who responded. That doesn't mean Officer Shabelsky, his heart wasn't racing. His adrenaline wasn't going. It probably was. But he knew he needed to control that and remain calm for everybody. We also know Bill's mind that night was clear. He didn't have any alcohol in his system. He didn't have any drugs in his system. He had some nicotine and he had some caffeine. But Riley was on meth. And we heard Dr. Kovac tell you what meth does to an individual, and Officer Grant tell you what meth does to an individual. Impulsive, unpredictable, violent, aggressive.
Okay.
That is exactly the Riley we saw in that video.
Hey guys, I'm gonna step away for a couple minutes. I know it's unrelated to trial stuff, but my oldest son has been super excited for a sleepover with all of his friends, and I just found out that his friends can't make it. So I'm gonna probably be doing some mama work for a little while. So I will continue the trial. Scott Bay will get her, and I will talk to you guys in a couple minutes, okay?
Aggressive, unpredictable when he lunges towards Bill and grabs that gun. Something Riley never would have done had he not been on meth. He was unpredictable. State wants you to believe couldn't have been an accident. Bill never said it was an accident, that Riley pulled the gun and the gun went off. But if Riley pulled that gun and Bill's finger did hit that trigger, in that moment when everything happened so quickly, Bill's number one thought is, my finger hit that trigger. I shot him. I had that gun. I shot him. He came at me. I had to do it. Those were Bill's words. You never heard Bill's words saying, I wanted to kill Riley. I'm glad I killed Riley. He never said any of that. Tiffany told you Riley went at Bill and the gun went off. Tiffany told you in those words that it was an accident. The state tried to also show you all of these text messages from Bill's phone showing how he intended to kill Riley, where he said, I'm hunting down thieves. He also said, I'm working on some paperwork, hunting down the third. He's not telling somebody he's going to get his gun and drive around hunting down somebody. It means I'm trying to find out who took my animals so I can get them and bring them home safely. Whoever took them signed their own death sentence. Because whoever took them, Bill knew, didn't know how to properly care for them or handle them. And they were venomous. They were going to bite that person and kill them. That's what he meant by signing their own death sentence. Not, I'm going to go kill whoever found my animals. Because we never heard any of those messages because they didn't exist. Solving it on the streets. It's exactly what Bill did. He was going around on the streets trying to find information. Just that night, he went to Tara's house to try to get more information at that time about his animals. There's no text messages on Bill's phone. I'm going to kill whoever did this. I'm going to kill Riley. I found out Riley's involved. I'm going to go kill him. I'm going to shoot whoever did this. There's no threats. How many of us have gotten so upset we've said, I'm so upset I could kill you? That wasn't even Bill's words. Bill never even said anything near that because he wasn't so upset he wanted to kill somebody. He was trying to find his animals and bring them home safely. I also want you to think about this. If Bill intended to kill Riley, what sort of evidence do you think we would have seen in this trial? If Bill had that gun, when he got out of his car and he was close to Riley earlier before the video kicked on, if he intended to kill Riley, why didn't he shoot Riley right then and there? Because he didn't intend to kill Riley. He didn't intend to use the gun. He didn't want to use the gun. If Bill intended to kill Riley, why was the gunshot in his right armpit? If Riley was on his knees when Bill shot him, why would Bill deliberately go to his right armpit and shoot him? Riley wasn't shot in the head. He wasn't shot in the back. He wasn't shot directly in the chest. If Bill intended to kill Riley, why would he intend to shoot him in the right armpit? If Bill intended to kill Riley that night, you heard this is a double-barrel shotgun. 2 triggers. Both barrels are loaded. The same trigger or trigger area. 1 trigger for the left barrel, 1 trigger for the right barrel. If Bill intended to kill Riley, why wouldn't he shoot him a second time? Because he didn't intend to kill Riley. When the shot went off and Riley let go of the gun and fell down is when Bill backed away. Because he didn't intend to shoot him. He didn't intend to kill him. If Bill intended to kill Riley, why immediately call 911 as soon as he could? As soon as Riley was shot, Bill asked Tiffany, "Where's my phone? We need to call 911. Tiffany had just had his phone. They get in his car, they find the phone, she dials it, hands it to Bill, and he's immediately talking to 911.
This is not my
Why?
screen.
If he intended to kill
So,
Riley, if he
Court TV
wanted
is
Riley to die,
doing
why
something
would he
odd
call
with their.
911 at all?
Yeah, this is the actual feed, guys. I don't know. I just wanted to pop in to say I wasn't boomering it. Is it okay? On a totally off topic, and I will get right back on, but is anyone else making their wish list for Amazon Prime Day? Because I have a couple things that I've been, you know, looking at for a while. So I'm definitely multitasking here. And, you know, 11-year-old newly minted man told me that he was okay with his friend, you know, having other things that happened to his family, so he couldn't come over, and he'll deal with it, you know, like a grown up now. So I'm glad that he took it that way.
Why wouldn't he sit around and wait to call 911? Tara told you as soon as she came outside, Bill was on the phone with somebody. If Bill intended to kill Riley, why wouldn't he just jump in his car and leave? And just leave Riley there? Because he cares for Riley. He didn't intend to shoot him. He didn't intend to kill him that night. State tries to argue to you that Bill testified about all of his officer training, yet he was terrified of Riley. As though police officers can't get scared in situations. When we were here for jury selection, a lot of you indicated, I could never be an officer because of the situation that they have to put themselves in. We all know officers, despite their years of training and experience, get scared in situations. As the judge told you, Bill doesn't need to prove his innocence. The state is bound to prove Bill guilty beyond a reasonable doubt. There's a reason that Bill's on this side and the state's on this side. Because over here, Bill starts with the presumption of innocence. The state wants you to find Bill guilty. Imagine there's a river flowing right between these two tables. Raging river. The state, in order to get Bill from innocent to guilty, needs to build a bridge. Bridge of evidence that you can hoist Bill on your shoulders and cross over that river to their side. That evidence needs to convince you beyond a reasonable doubt that Bill's guilty. The judge also told you that if you can reconcile the evidence with any reasonable hypothesis consistent with Bill's innocence, you should do so. And Riley reaching at Bill, grabbing that gun and pulling it isn't just a reasonable hypothesis in this case. It's consistent with the DNA evidence. It's consistent with Dr. Kovac's testimony. It's consistent with the neighbor's testimony. It's consistent with the video that we all saw. It's consistent with that timeline that you saw we put together as this trial went on. It all points to the same conclusion. It's not just a reasonable hypothesis. It's the truth of what happened. That Riley came at Bill, grabbed that gun, and the gun went off. It was an accident, not a crime that Bill committed that night. That's why I'm asking you, during your deliberations, ignore the sympathy and the emotion that all of us feel on this case. Look at the evidence that's been presented and look at the truth of what happened after that video goes off and return a verdict of not guilty. Thank you.
I think he did a pretty good job. I don't have any real criticisms. And now let's just survive. I'm sure Miss Smarmy Pants will be back and we will get to listen to Kathy Bates for 17 million other hours. And now at least we know the identity of Hair Helmet over here. I figured he was a talking head. Yeah, I think he did a great job. Now, I mean, I know body language isn't like super serial, but it does worry me if the jury is maybe looking more favorable, but I also don't believe a man with hair that poofed.
We are late for taking our morning break, so we will take a break at this time.
No worries.
Ms. Isherwood, any idea how long your rebuttal is going to be?
Mr. Sledge's gonna do it, but we're more concerned right now that it was that self-defense wasn't brought up in the closing argument.
It's up to the jury.
It's up
They've
to the
heard
jury.
evidence throughout the trial that it could be self-defense.
But to the actual shooting itself, there was no evidence.
The judge
that
has spoken,
there was
sir.
an
Stop.
intentional use of force. And no argument that there was an intentional use of force.
The jury's been instructed. I think the facts that have been adduced could be found to support the instructions.
Yeah,
I know we probably didn't make a clear record, but I had concerns about some inconsistency of the instructions, but there's nothing that forbids the defense from having multiple theories of defense. It's primarily the state that needs to be consistent in its analysis. So,
There were no multiple theories advanced in the argument.
and it's completely up to the defense the type of argument they want to make in closing. They don't have to do anything. They can stand up and say, the state hasn't proved its case. Find them not guilty. They don't need to say why they should.
Y'all, just one time in a trial, I want someone to pull a doggone or, a Joe Pesci and like, Your Honor, everything that guy said was bullshit. But yeah, I know. I like this judge. I just wish better. Yes, please like and subscribe. I am new to YouTube, guys. I am learning my groove. So it's been pointed out by a couple people I talk too much or not enough or y'all, I'm learning. And this is just going to be me. I'm going to try to get better at a couple of things and I'm just going to work on finding my flow of, you know, different things. And this is my first trial I'm kind of doing all by myself. I gave up on Scott Peterson. So this is my first live trial that's kind of just been me. I mean, I'll jump in on David's things or I'll jump in on Nicholas's things. I know you degenerates. So already phrasing on me. Um, but y'all are sticking with me through this duct tape and, learning about it. Yeah, you guys, to see the state bring up victims and re-victimize them for something that I don't think is gonna stick, s and to make those parents watch that or listen to those sounds, go I mean, I just got the audio, and I will not rewatch, I will not rewatch that day because it was horrible. So fair warning, if you do go to the Peterson case, I believe, day 1, after opening statements, they play horrific audio.
He found not guilty. Any objection to that argument is overruled. You have a legitimate argument. If not, how long is your rebuttal going to be?
Well, I haven't timed it, so
Just an estimate. I want to be able to tell them when to order lunch.
I would say probably less than 20 minutes.
Okay, so we could have lunch early potentially today. All right, we will recess.
Well, at least it isn't Kathy Bates again. How long is the rant that Ricada does? Oh, well, I'm past 2 hours. You guys, it's a Ricada clip, so it's going to have the naughty words in it. It's about 19 minutes, so if I do it on 1.25 speed, we might get through it, but if it's going to, if you're at work, it's Ricada. I'm giving a Ricada warning, okay? Y'all, it's Ricada. It's not Mr. Oh, she looks terribly thin. I've never been terribly thin, so I don't know. Yeah, I don't know why I also don't know why he has feet shackles on, but I'm sure he can walk just a little bit. But yeah, I'm giving you a Ricada warning. These words and language are not a Mo approved thing. Well, they're a Mo approved thing, but not out of the mouth of Mo. So if you are at work or listening, I would suggest earbuds. I have given you a warning. I'm getting ready to pull it up, so just fair warning. I don't want to get you in trouble at your workplace. All right. We are all strapped in and ready to Ricada go.
The jury analysis meta that has existed around these trials. I like DUI guy. I like James from court. I care way less about their jury observations and more about the rumblings of the gallery. I care way more about what's going on in the courtroom and what they're perceiving from the attorneys from the gallery's perspective than their impressions of the jury. Their impressions of the jury are worth less to me than shit.
Well, I will tell you this.
You know what I love about Ricada is you want to be his friend, and he tells you the most honest things about yourself. Like, you know, he's what how have I described him? He's a jerk, but he's a lovable jerk, and he tells you in such a way that you know it's just honesty, and he's not trying to bust your balls too hard. I'm breaking this up because I don't wanna steal, like, I don't know the, Emily Post of using, other creators' stuff and commenting on it. I mean, I'll screw law and C word. Any old time. But I don't want these guys to feel like I'm, you know, I don't know, poaching their stuff. But if Farrell says Nick is fine with it, Farrell knows everything.
As someone, I went to the death trial.
Yeah, I know. I hated your jury analysis too.
That's okay. I wasn't able to provide really much of any jury analysis because my eyes are so bad. I could barely see like their
Okay,
faces
I
from how
just
far away we were.
wanted to be
Pointless,
respectful.
Joe.
But I will tell you this: there's like the only time that you can get anything from it is if there's like one juror there who's doing something similar to like what like juror number 1 was, which is like basically.
Sir, I would be that juror because my face is in all cap locks at all time. That's good. I should have looked that up, and then I thought about it as I was already watching it, so, you know.
Basically as Amber was
Oh, yes,
testifying, like he was
please
practically
watch
like
and
making
follow
motions
all
like
of these guys. So, Ricada Law, I know he has a bigger thing on locals, so if you wanna follow him more, I think locals is the way to go. Law of Self-Defense, I believe he also has a locals. Joe, from Good Logic, Kurt from Uncivil, who may or may not be my spirit animal because he knows all the things and he's a little bit awkward and self-conscious, but he's so funny and so dry. And then, Potentially Criminal, Sean. I don't watch Sean as much. I know you guys are gonna be shocked, but with 6 kids and and all the other things, I get a little sidetracked from my YouTube watching, which is the most important.
like he was like literally like mocking her and like making faces while she was talking. So like that you sort of can get something from. And the other thing I'll say is everyone who went and analyzed, everyone felt that there was one juror there who remained on the jury, didn't get thrown off by the end, who was the most pro Amber out of all. Like we all individually identified the same person as being least impressed by the Depp team's case.
The best part of that is you were probably all fucking wrong about which one it was.
All right,
It's
wait,
very possible.
we are
We'll never
back.
know.
We
We'll
will
never know.
God,
we will stop this. He is back on so at least we have male lawyer. Oh, let me pull it back to where he started. Okay, he's been on for several minutes. Mo was off the job. I didn't realize I had paused it. So we are about 9 minutes behind. But we will get back to this.
Mr. Saji, you may proceed.
Ladies and gentlemen, I will make this as brief as I can.
Praise Jeebus.
There's was a lot of discussion by Attorney Hogan about Bill didn't intend to kill Riley, right? That he didn't tell anyone he wanted to hurt him or kill him. If he wanted to kill him, why didn't he shoot him various other places or multiple times? But the other, in defining what is intent, one half, which attorney of the definition, or one possible definition Attorney Hogan focused on, is the mental purpose to take a life. Another definition is, was the defendant aware that his conduct was practically certain to cause death? Keep that in mind. We heard that on the 19th, that Bill was going to 400 Mill Street when he was stopped by law enforcement. But if he hadn't been, who did he expect to find there? But Riley Minute Powell, the same person who he's so scared of. After there was Attorney Hogan said after he knew about the location of the animals,
Is it me, or does he seem very disjointed, very nervous? I mean, even Kathy Bates had a fairly confident air about her. He just seems very nervous. Or is it me? I could be.
was still concerned that if he went there, if Riley showed up, there'd be a confrontation. But what reason did he have to believe that? That day, Bill had no contact with Riley before what happened shortly before shooting him. There were no messages exchanged. He had no reason to believe that Riley was going to be violent with him or tried to be. When you heard Attorney Hogan talk about when Riley removed his jacket, at that point, Bill became more convinced that he was unarmed. So he was willing, or chose to give the gun to Tiffany. But we've seen this video, and I won't play it again. What does Bill say to Tiffany? Hold this on your son. Hold this on your son. Hold what? A loaded shotgun with the hammers cocked, ready to be.
To which Tiffany could very easily have said, "No, I'm not holding a weapon on my son." Don't take Tiffany's agency away. Tiffany Rose is Tiffany Rose's own boss.
Fired. Sure seems like it was an option, right? Hold it on your son. Bill also, there was a lot discussed about his.
Wow, he sounds like me when I first started doing videos. It's so hard to coalesce your thoughts and have to use a script and, be animated. Does he not do, I guess, statements? Is he the replacement?
There was no substances found in his blood, right? He was of clear mind. That's what his attorney said. So he was of clear mind when he chased after Riley towards the car. When he took the gun back from Tiffany. When he retreated, which, as we know on the video, is...
Sir, objection to a grown-ass man in a courtroom using finger quotes. Sir, I am semi-professional, and even I would not dare to use finger quotes in a freaking courtroom.
If that's a retreat, it was maybe a few steps backwards. He was scared, he said, that Riley could arm himself with. If Bill took 5 steps backwards and held the shotgun towards Riley, if Riley came at him with a baseball bat, a knife, a hoe, or...
It's after 2 hours. For fuck's sake. It is a goddamn pickaxe. It's a pickaxe. Just look at Yosemite Sam. Look at freaking Toy Story, 3 or 4 with, Stinky Pete. Look at Google.
Hammer. At that point, certainly a shotgun double barrel 12 gauge could have pretty easily overcome that. But that's not what he chose to do. He chose to get closer.
I'm feeling bad for this man. Maybe do I have it on normal? I have it on normal speed. Um, I mean, I'm not trying to stop it so often, but it's just so very jarring. And then I feel like maybe I'm going to be very blunt and honest with you guys. Today is not a great day pain-wise, so sometimes I can get a little you kind of fog out if you know anyone with fibromyalgia or things like that. If it's a bad or not a great pain day, you know, I tend not to pick up everything. So I sometimes stop today to make sure that I'm observing things right because sometimes I can be a little tangenty.
Again, Bill's mind was clear. Stop or I'll shoot. His mind was clear when he put his finger inside the trigger guard. So there's a tussle over the gun, being pulled back and forth. His mind's clear when he puts his finger inside that trigger guard. Inside of a loaded, ready-to-fire shotgun. His mind is clear when he calls 911 and says that he confronted Riley. Riley came at him, and I shot him. He says, well, if Attorney Hogan said if Tara didn't know if Riley was faking it, then how would Bill? But what we know is that Bill was the one holding the shotgun that was pushed into Riley's chest. He was the one holding the shotgun when it discharged into him. So how would he know? It's not a tough question because he was the one who shot him from just the length of that shotgun. He then claims and wants us to believe.
Does this, Farrell, if you can check out and do your Google Kung Fu, does he have a son about the age of Riley? Or a son that just passed away? Because if this ish is making a man traumatized with grief try to do this, that can be my only reason that I think he's crying. I don't know.
He was still scared of Riley. And that it's an officer's priority to clear the scene. Again, he still wants us to believe that somehow he's following law enforcement training and yet not at the same time. Earlier, when he still thought.
Okay, crud. I knew, okay, Murph had. Sorry, she had slides with everyone's names. And I'm trying to pull it up right now. Murph will probably be faster because y'all know. I thought you wrote it, no, you wrote down Miss Ishwater or Isherers. I'm sorry, guys, for
Riley was a threat.
stopping.
What did he do? He gave the gun to Tiffany and then approached with a taser. So if he's still, even if we can give him that benefit of the doubt that Riley was maybe still alive and he was still concerned about whether he would get up and pose a threat. Why didn't he do the same thing? Say, Tiffany, hold this. I'm going to go to Riley. Because he didn't know he was dead. Yes, Dr. Kovacs told us that. But that's a doctor. That's a medical examiner. That's after performing an autopsy and seeing all of the catastrophic damage to Riley's lungs, his heart. Bill didn't know that, but he did nothing to try to find out. So we can sit here today and tell you that it would have been ineffective. But that's not what he knew then. Bill also wants us to believe he was devastated about Riley's death, because we saw him cry on that body camera, right? When he first learned about it, that he was dead. So apparently shooting him in the chest, that's no big deal as long as he pulls through. The only reason he has to be upset is if he's dead. Ignoring the testimony that Bill actually saw the search warrant at the hospital that said the charge was first-degree intentional homicide. Bill, a former police officer, is going to try to have us believe that he didn't understand that that meant someone was dead? And who else would be dead that he would be being investigated for, if not Riley? He knew. Again, intent is if you are aware that your conduct is practically certain to cause death. Bill loaded that gun, and whether he cocked the hammers when he got it out of the car or when he took it back from Tiffany, he testified that he knew they were cocked. So when he knew when he was struggling with Riley, if that's in fact what happened, that if he put his finger in the trigger guard and Riley pulled that gun, his finger would pull the trigger. Practically certain. The last thing I want to stress, and this is from the instruction that you were given about reasonable doubt. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. And I think the truth has been pretty clearly laid out before you today, this week. Thank you.
Well, it was no, you can't handle the truth. I don't know, guys. This guy looked like he was terrified to be up there. He was, he was searching for Indigo, which, I mean, would make all of us sad if we had lost her. But oh my gosh, okay. So I do kind of want to see what the body language guy says about, this particular rebuttal, because if they were agreeing with Miss Kathy Bates, I think the defense was very compelling. This would have turned me off. He doesn't seem like he's confident of anything they've said.
Now, members of the jury, the duties of counsel in the court have been performed. Case has been argued by counsel. The court has instructed you on the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision in this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offense charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following three forms of a verdict will be submitted to you concerning the charges in this case. One reading, we, the jury, find the defendant William C. Zielinski guilty of first-degree intentional homicide as charged in the information. A second reading, we, the jury, find the defendant William C. Zielinski guilty of second-degree intentional homicide. And a third reading, we, the jury, find the defendant William C. Zielinski not guilty. It is for you to determine which one of the forms of the verdict submitted you will bring in as your verdict in this case. This is a criminal matter, not a civil case. Therefore, before you, the jury, may return a verdict which may be legally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other person or juror. If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of the trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached
both
the
signed
verdict,
and
a presiding
notepadded
juror
that,
will
or
notify
starred
the
and
bailiff that a
notepadded that.
verdict has been reached. Everyone will return
Oh,
to the
wow.
courtroom. The verdict will be read in open court, and the court may ask each of you if you agree with the verdict. As you may have noticed, I indicated there have to be 12 jurors in agreement, unanimity. There are 15 of you here today. We had the extra jurors in case something were to happen during the week of the trial where life intervenes and someone could not sit and deliberate and be a member of the jury. We have randomly drawn 3 of you who will be excused from deliberations. I want to thank those 3 individuals with my deepest gratitude for taking the time to be here. I'd encourage you, if you desire, to sit and listen to the ultimate end of the trial. And it is even possible, if something were to happen during the deliberation process where someone couldn't serve, one of you, the 3 of you might still even be called to join the jury. Deliberations would have to start completely anew, and that's a highly unlikely circumstance, but the 3 of you which are being released now have really performed a very important purpose, so I want to expressly thank you.
No.
So you want to
No, we don't.
you want me to announce them?
Oh, look at Miss Sassy Pants over here. She had just straight blonde hair a couple days ago, but now she's got some, looks like teal little tips on her hair. Look at you, Miss Sassy Pants.
Given the circumstances of this trial, is it your instruction that the alternate should avoid the media?
It would be my instruction that you avoid the media until a verdict comes in from the jury as a whole. But obviously, once a verdict has comes in, as I told you earlier, all of my admonitions about not talking with family members or anyone about the case are all lifted. You can talk with anyone you want after the jury verdict comes in. The 3 that are being excused are going to be released back to the jury assembly room. Your lunches will be delivered to you there. The other 12 of you will go back into the jury room, but we need to have those remaining, the officers sworn at this time. So the bailiffs.
Please raise your right hand. Do you swear that you will, to the utmost of your ability, keep all jurors sworn on this trial together in some private and convenient place, subject to the direction of the court until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God?
I do.
Okay, the 3 of you that are being released right now, if you have items in the jury room, why don't you retrieve those right now, and then you can go to the jury assembly room and get your lunch. Will be a little while. We ordered it, but it's not here yet.
I wonder what they got for lunch. It's about lunchtime here, and I'm like, am I hungry, or do I just want to keep streaming?
Here is.
Here, one of them asked, can I just go home?
Technically, after they eat, yes.
We could let the bailiff know.
Can also indicate that apparently some of them were concerned if after deliberation starts, if I'd allow them to have nicotine breaks. And I said, if they really need it, I would allow it. We'll bring everyone in here and those who need to take the break because they can't continue to deliberate without nicotine. So that's
Sorry about that, guys.
Advise the bailiffs. We will handle that issue. Do you have an X? The verdicts? I'll use it.
I would allow it.
So the excused ones are out. Okay. Members of the jury, enjoy your lunch and start your deliberations. You can work right through lunch. Thank you.
I was about to say Salvador because that would be something he would say, but it's Snivels 44. I will get better at reading out names and stuff. One day I'll be a real YouTuber. I know. What is for lunch?
Please be seated. We are outside the presence of the jury. I don't know if counsel have any thoughts about exhibits. It's the court's thought that perhaps we not send any exhibits in unless they are specifically requested, particularly since some of those exhibits are dangerous weapons.
I would wholeheartedly agree with that.
Ma'am, you are the one that daggone was lighting up everyone, smarmy. Yeah, we can't trust them with that. Ma'am.
But I think if they ask for specific exhibits, we will probably give them to them, or we'll address it at that time. But I think they've seen most of the exhibits, and some exhibits will be hard because they're electronic exhibits. It's not easy to send in. So absent a request, I'm not sending any in unless someone wants any particular exhibit to go in.
And Your Honor, I would suggest if they wanted to see something electronic, that we do it in the courtroom.
We bring them in and show it here.
That all makes sense to the defense as well.
Okay. I assume you will probably be in your office. Do you have a phone number that you want us to call, or do you know where you will be?
I did provide my phone number to the clerk.
You still have it? You same number?
Yes.
All right. Then we will recess.
All right. Well, how do you guys think it went? I am going to learn how to do a poll. Look, y'all, David's going to have to send me dummy slides as per usual to learn. I think that, Salvador, if you can keep me up on what the Twitter god said, but I think that, I think the defense did a good job. I don't think he was appealing to emotion, though. And I don't know if that will hurt them with the jury. I have 6 kids. That is a large man, and I mean tall and yeah, Salvador, if they've posted anything on the body language during the rebuttal, my hope is that if they were for the if they were for the state while she was appealing to a lot of emotion, and then the defense came back and really put in all the facts, the rebuttal, I think, was so shaky and so disjointed that I was if I'm a juror in his rebuttal, like I would say the same things I'm saying on here. I would be looking at another person and writing in my notes, wonder if he had son pass away. Why is this such a topic of such difficulty for him? I hope so. But I'm cautiously optimistic, but then again, I don't know, courts are weird people. They are weird, weird things. And Lord, we don't know what the heck is going to go on half the time. Yeah, well, I was, taking a couple bites of things and then didn't want to do the gross ASMR food chewing thing that my kids. It is like that shiver up your spine to hear people make chewing noises. And my sons want to watch all the ASMRs where they get the like crunchy things. It's so gross. All right, let's go back to Ricada since I'm not. I'll keep it. Let me see as we get back. Okay, it's just off now. I will keep an eye on the feed though, but you guys don't have to watch the clock, and we will go back to Ricada giving us his popely wisdom on body language.
I hate it. That somebody
You're
said
right.
this-
I can't deny that.
That somebody seven says, "Stop lying, Nick. You cared about jury analysis during the
I could
depth. That's
too.
why you brought them. That you brought them on." No. I said over and over that I didn't care. I didn't care. I brought it on because the audience was demanding it, and
Yeah.
I run a show ultimately that is based on the audience buying in, the audience participation. If the audience wants to see jury analysis, look, if you guys are so fucking retarded that you guys want someone to tell you what the jury is doing, you need someone else's biased perspective.
I love Nick, but you never feel quite as smart or quite as full of yourself after you get done talking to Nick. He's like a truth mirror. And he's he does it in such a blunt way that you kind of go, yeah, you're kind of right. I do have some ish I should probably take care of, but it's It's entertaining, and I do like other people's insights because sometimes I don't read social cues as well as, others, and I can't, um I'm exposed to small children who telegraph very well sometimes what they're thinking, except for teenage girls. So, I sometimes
And
don't get
believe
adult
me,
things.
the jury leaned in during the financial testimony. Tell me what that means without bias. Because with bias towards the defense, it means, oh, the jury is listening for all the points in which Alex Murdaugh is not guilty. If they're biased towards the prosecution, it means, oh, the jury is leaning in to find all the places he fucked these people over. It means literally nothing. You can discern nothing from it. And by the way, the body language panel.
Oh my gosh. Kurt, this is an unfortunate pause. I'm not going to do that to Kurt, my spirit animal. I'm going to go just 5 seconds. But Kurt's face is in all caps, and that's what I love about Kurt. I mean, he and I are not good at if we smell BS and we think BS, our face is going to say BS.
With me that their analysis is absolutely worthless because they know nothing about the jury personally and they can only make general descriptions about what is going on. You guys are being fucking hoodwinked, suckered, and grifted over and over and over by jury analysis by people who aren't in the case. The only jury analysts that matters, the only ones are the ones
Hi,
employed
Wendy.
by the state and by the defense
Oh my
to
gosh, should we do
research
a
the
fake
Facebook profiles, the Twitter profiles.
should we do a fake body, you know, body language analysis? Bronca is bored right now, and I can tell because he's looking at his phone. Joe is staring off into the distance, so he must be thinking of his next comeback as to why Nick is completely wrong. Kurt is simply, I know Farrell, if they needed a finder outer person, I think it's called Oppo research, but I prefer finder outer. You would be mine. And Sean is just trying to be neutral right now because it's not his rant. Um, welcome to my, semi-professional trial chat watcher and semi-professional behavioral analysis person since Baker isn't here right now. In fact, let me Twitter a tweet thing at Baker and see if he wants to come on. I know his daughter graduated and he was enjoying family time, but he might be done with family time now, or he might be like at that family time where it's like, "Oh, I need a break or an excuse to get out of family time for about 20 minutes." So I have sent him a tweetvite, and we are back to being on task-ish. I'm trying to
Profiles, the
start it on
Instagram
my
messages of all
StreamYard.
of these people who have made the decisions to put these people on the jury and then have an analysis based on the psychological profiles that they have built if they have done it. And maybe they have, maybe they haven't. You won't ever know because you're not privy to that information. Everybody else going in and doing jury analysis is bringing all of their bias in. It's why I fucking hate it. I hate it. I hate it. I hate it. Look, if I went down to court and did a jury analysis of Alec Murdaugh, all I'd say is all these jurors are biased against the state. You know why? Because I'm biased against the state. And I would read literally goddamn everything into that.
Everyone should be a Dale Gribble. It could be. I may have a little bit of the contrarian in me. I know. I love how Bronca's just kinda there, and he's listening, but he's got 900 billion other things to do because he's, got the school and everything else. Kurt's just getting steadily redder because he's trying not to laugh hysterically, too bad, and then Sean just has a majestic beard, and he's just, giggling to himself. This is why you can't hate Ricada.
that. The
Tag
problem
comment,
with
I'll get
jury
back at you.
analysis is I don't know what the speaker's biases are, and neither do you. It's a grift. It's a work. It's all of the things just to keep you watching. Why do you think I bring them on? I don't bring them on for witty analysis or smart, educated expertise. There's no objective standard for a jury analysis. Execution means,
Oh,
the
wait.
jury is
Ouch. Ouch and burn. Yikes. Oof. Does DUI guy and Law and Lumber, do they have aloe? Do they have ice cubes? Because that's a whole lot of stinging right there. Yeah, I know. Dagger right to my heart. Like, my sister done stabbed me. Oh, which reminds me, her Giggle McStabby Pants, oh gosh, Fatima Marzipan, I think. Don't come at me for or Fatima. Anyway, her either plea deal meeting or where she pleas is going to be in July, and we will be covering that. That was the first case to start this What in the Walmart. So you guys are free to go back and listen to that. Sal and I listened to the interrogation of both the stabber and the fake boyfriend, and also in another throuple, but with sisters. But yeah, it's all sorts of fun. We get all sorts of off the track. So if you like just straight news, it might not be for you, but if you like to tangent out and get very scared about someone, it is the stream for you guys to rewatch.
Nothing. You can discern nothing from it. And by the way, the body language panel, fuck those guys. I love them. They're great. They're all super smart, and they will all agree with me that their analysis is absolutely worthless.
Oh my gosh. See, this is total Ricada. Like, I absolutely love them, but also F them. F you right in your eyeball. Just on bad days, I need to start remembering to watch Ricada, because you guys, between chat and this, I am not as uncomfortable as I would be.
Because they know nothing about the jury personally, and they can only make general descriptions about what is going on. You guys are being fucking hoodwinked, suckered, and grifted over and over and over by jury analysis by people who aren't in the case. The only jury analyst that matters.
Well, at least he didn't say analysis, which I have been known to do. But,
the only ones are the ones employed by the state and by the defense to research the Facebook profiles, the Twitter profiles, the Instagram messages of all of these people who have made the decisions to put these people on the jury, and then have an analysis based on the psychological profiles that they have built, if they have done it. And maybe they have, maybe they haven't. You won't ever know, because you're not privy to that information. Everybody else going in and doing jury analysis is bringing all of their bias in. It's why I fucking hate it. I hate it. I hate it. I hate it.
I don't know. It's almost like he's being very subtle. He's being very subtle. I don't quite understand. His body language is, well, he seems aggressive. The chin is pointed up. He's forward facing in his posture. Bronca is also looking a little aggressive, but closed off. Is he turtling a little bit? Yes, I may have gotten
if
into
I
the body
went down to
language
court
stuff too.
and did a jury analysis of Alec Murdaugh, all I'd say is all these jurors are biased against the state. You know why? Because I'm biased against the state, and I would read literally goddamn everything into that. The problem with jury analysis is I don't know what the speakers.
Y'all, Joe is blowing his nose. Obviously, he is blowing out the inner resentment so that he can be polite when he talks to Ricada again.
biases are, and neither do you. It's a grift. It's a work. It's all of the things just to keep you watching. Why do you think I bring them on? I don't bring them on for witty analysis or smart,
Oh, sorry, I went
educated
backwards. I'm
expertise.
so sorry.
There's no objective standard for a jury analysis. I bring them on because you goddamn ask me to, because no matter how many times I tell you retarded people that it's absolutely fucking worthless, you're like, well, bring on James from court. Bring on DUI guy. They're in the courtroom. They know. They don't know goddamn anything. I love them. I think they're wonderful. I want DUI guys legal analysis all day long. I never want to hear him talk about a jury in my fucking life unless
Nick, you need to
it's
give me the
his
keys. You're done.
jury.
Okay, you guys, I'm definitely gonna have to watch more Sean. I'm subscribed to Sean, but I'm subscribed to like everyone on LawTube, and there are only so many hours in the day. But that was perfect. I'm dead. We're all dumb. We're all very dumb. And how dumb is it that I never thought about someone's personal bias until Nick said it, and then I'm like, I is dumb. I is not smart today. Because he's right. I would go in there and definitely think, look, everyone is on the defense side because the state sucks balls. All of them. Oh, okay. If you guys have a favorite Sean rant and you are a member of David's Discord, as we are going through Verdict Watch, we can watch a Sean rant. But then I'm probably going to let me see. I'm sorry. What is it? I am probably going to turn this particular stream off, do some laundry, I have to mop the floors. So we'll probably watch the end of this rant, watch a Sean rant, and then I'm going to go off of this stream, and then I will come back if I see anything about the verdict. Jamie hooked me up with the Twitter verdict watch for law and crime. So we are there. And if you guys see something and you're on my tweet lit, y'all know I don't know how to do Twitter. Just shout at me real loud and I'll figure it out.
No, goddamn it, Sean. This is honesty hour. If DUI guy is in his own court, if he has picked his own jury, if he's done his own research, I want to know about it. If he saunters into court 3 weeks in, Sean, he's 3 weeks in. If he walks in, I'm going to give you jury analysis. Fuck off, DUI guy. I love you, but you have nothing of value to add about the goddamn jury.
You know, this is the kind of passion that I put into, okay, my husband has to deal with me, but I got mad about the Berenstain Bears because we were reading the book to my youngest son. And I said, as a kid, I was always really weirded out by the Berenstain Bears because how are you going to name your first kid brother when you don't know if you're going to have another kid? So he could be brother to no one. He'd just be son. Why not name him son? But these are the kind of rants, because then my husband's like, why does it matter? I was like, because they're being presumptuous and I don't like it. And we all agreed on English. Pray for Mr. Moe. He has to live with this.
I care about your opinion on the case. That's why I bring him on. And because you assholes ask me to. Stop being grifted and duped by these fucking people. Stop it. Stop it. Stop it. All of us are just giving our biased perspectives on literally everything. I am obviously pro-defense. I was a defense attorney. I will always be a defense attorney. The state can fist itself until it reaches its tonsil.
Oh my gosh. You know that inside running monologue? Oh my, I'm going to start laughing so hard I'm crying. Nick gets started and then he's like me. He's like, and this and that. And I love Kurt. Kurt is like, passive agree. But I'm really uncomfortable about showing that I agree. Thank you. Yes, Lefty, this was amazing. like I said, today is not a great day with pain, so having something that makes me laugh and not think about it is a number one. Okay, so let's go into this. Nick appears super red and aggressive. He's leaning forward. The chin is sort of parallel now, not up. So I don't think we'll have any, you know, imminent violence. Bronca's like, I like what you're hearing. That's his posture to me. Joe is just probably texting Kurt saying, we got him going. And Sean is kinda like dad, like, "Oh, I agree with every single thing you say, but you're a toddler and you're not supposed to be cursing, son. So, next time you say your darn cup fell down, and you don't say god dang it at the end of it."
For all I care. Fuck the state. Prove to me they're guilty. You know what you're getting when a jury analyst James from court. I love the guy. He's smart. He's insightful. He's like a 23-year-old journalism major. What is this guy telling you about a jury ever? He didn't pick them. He has no qualifications in law. He's just a guy who went into a courtroom, and you're out here like, oh, get James from court on. We want his jury analysis. Why do you want his?
Do you ever think that Ricada's wife comes down and she's like, because I know Mr. Mo, when I was just watching the chat, I would start just giggle snorting hysterically, um, at certain times or at a comment, and he's like, "What are you listening to?" And I was like, "Well, I can't really explain it, you had to be there, but there was this thing and the other thing." I hope he has a soundproofed office.
His jury analysis. I want his opinions about from a journalistic perspective about what's going on in the courtroom, what's outside the courtroom, what
I would
people are
hope.
talking about, what's the buzz. I want him interviewing people who are in the gallery. That's what James should be doing. The fact that he's doing jury analysis means, one, he's shortchanging his own abilities, and two, he's giving into the fucking grift that, for whatever reason, all the people who watch me and Emily D. Baker and Law and Crime are like, oh God, I really want to find out. No, you don't. It's
Giving into the
worthless.
grift?
It's
You're saying he's
worthless.
giving into the grift?
Yes.
Hold on a
absolutely.
second, but
You know I'm giving into the grift.
Oh Lord. Oh wow. This is why I love Nick. You know, he commits and he's like, "No, sure, I understand this is hypocritical. You have no idea. I am grifting my ever living, man boobs off." But he's like, "But these people are irritating me, so they're criminals about it." Oh, okay. Well, oh my gosh. Okay.
I hate this trial. I hate everything about this. 3 weeks. I've wasted 3 fucking weeks of my life, Kurt. I'm sitting here and I'm going, why in goddamn hell am I watching this? You know what I could be doing, Kurt? No, I could be sleeping. I could be eating. I could be cooking. I could be going out and doing chores. I could be spending time with my kids. I could be spending time with my wife. I'd be going to the cities and getting goddamn happy ending massages. I don't know.
I did feel this level of mad at the Scott Peterson trial. I was like, of course I would jump into a Scott Peterson trial and think it was the other Scott Peterson. But yeah, this is maybe not at his level 13, Spinal Tap. He's just gone past 11. He's at 13. Oh, yeah, I didn't get into the Murdaugh trial that much. I was kinda like, "Meh." Eh.
Literally anything other than watching this trial. Why am
But
I
you do it
watching
for the
this trial?
grift.
It's
You do
a
it for the
fucking
grift.
grift. Of course it is.
But wait a
But you're
second.
chastising them for the grift. That's the
Isn't-
part I don't
But
understand.
isn't all like most people? I'd say that's true. But
James is giving into the grift. He knows he's going
DUI
into
guy
the
is
grift.
really good at reading a jury. Wouldn't you
No,
recognize?
I disagree with you, Joe. He's good at reading his.
Joe, dang it. Nick's heart's gonna explode out of his daggone chest. And it's gonna be Joe's baiting problem. Oh my God. Joe is my middle son. My middle son will pick and peck and pick. And the thing will be almost dead. It'll be almost over, and he'll just like sassy comment somewhere.
His own jury. How can he possibly be good? 3 weeks in, he wasn't at voir dire.
No.
He doesn't know the defense trial strategy. How can you read a jury if you don't even know the goddamn strategy of either side? You're guessing.
He's picked juries before. He
Yes,
understands a
in
jury.
his cases, with his strategy, with his perspective in line. DUI guy says, okay, here's what I got. I got a guy who blew a .09 when .08 is the legal limit. All he had to do was defer the he had 2 shots or 3 shots. I don't know, maybe he's 130 pounds. He had 3 shots of whiskey at the bar. He's almost home. All he had to do was take a blood test instead of the breathalyzer. He would have blood tested in 2 hours, a .07. They wouldn't have had a perspective thing. He was swerving within the line, some bullshit excuse. DUI guy knows exactly what his angle of attack is here. You tell me that DUI guy or James of Court knows either party's exact theory of this case. You know how I know it's a fucking lie? None of us, no one on this panel who are all lawyers can articulate either side's actual theory of the case. We can guess at it. We can take stabs at it. We can get close.
Yeah.
None of us are on the team. None of us know what we're going to go up against. None of us have seen the discovery.
But I think they're going to eat lunch first. So, and they wouldn't tell us what lunch was.
Or the witness list, or have depositions or interviews. Not a goddamn one of us. DUI guy walks into there 3 weeks into court, and we're supposed to expect that his jury analysis has some merit because in his own trials, he picks juries in his own trials.
It's also that he was at the Depp trial. He has experience in reading a
Depp
jury.
trial is completely different from this, Joe. Don't fuck with me. Don't you even dare. Don't
Yes,
you
Depp
fucking
is
dare.
100% different than this.
Joe, come on. You know the difference between high profile social media and mass media civil litigation versus a goddamn criminal defendant who is deeply entrenched in South Carolina law. These are way different areas. It's not even fucking close. And every goddamn law tuber out there
Well,
who's like,
as I'm not a law tuber, I feel like I'm left out of this, and that's okay. This is just a warning if you are coming into this viewing that we are watching Ricada clips. So if you are, at work around small children who will repeat these things or anything else, we are watching Ricada. You have been warned. There are all the slur bombs and F bombs, and yeah, see, no one expects me to be professional except for Sarah Boone. And Lord, I love that woman. I know. I keep looking at I want a BP monitor. I feel like, would it be sick and perverse to want to watch the little like red thing go from green to yellow to red? I mean, that would probably be terrible, but a great idea. I'll send it to him.
oh, I have special insight. I was XYZ. Fuck off. None of you know goddamn shit. We're all walking into this fucking blind. People are like, oh, didn't you read the articles? Didn't you watch the podcast? Didn't you watch the documentary on HBO?
Okay, you know what? Sometimes I can be a little bit like that with true crime. So maybe it's just a scotch near home. Maybe I need to, tone it down just a little bit. No, it's somewhat tawdry a term, and I love double or single entendres, if you will. But I am a layperson, and I think there's been a little bit of issues with people calling themselves, to the lawyers. I think it's important to some of them, not all or not, I don't even know, but there's a distinction between people who have law degrees, which I totally get. You guys, that is LawTube, if LawTube is a thing. So LayTube is just lay people, and it sounds like it's completely a single entendre. So I like it. But yeah, I don't know that I'm a crime tuber because I watched trials, and trial tuber sounded weird and somewhat medical and like I'm an experimental person. So that's what I came up with. All right, we'll probably finish this up and then I'm going to go make macaroni for the small people that I apparently had a herd of.
No, you know why? All of that shit is goddamn worthless. Put it in front of the fucking court and then talk to me. None of us know anything. And Jesus Christ, if we're pretending that we know the strategy, if you can't cite to a fucking attorney on the case on either side, you're literally lying. And I'm so goddamn sick of this thing that we do. I'm fucking sick of it. The illusion that, oh, yes, we're lawyers, we know. Guys, we're with all of you. We're with you in the chat. We're with every single one.
I would like to point out that Ricada said we don't need a law degree to be in chat. Awesome. I think there is a place, and you guys, these lawyers went through schooling and all the stuff that I have not had time or really the desire to do. So take law to be proud of it. It's not going to offend me if you call me a crime tuber. I mean, just don't call me an influencer. I feel like that's a little weird because I don't want to influence anyone. Good Lord. If I am your personal leader and or an example to go by, sweetie, I am a hot mess express most days. Turn back around. This is caution lights, if you will.
One of you, we walk into these cases blind. Oh, yeah. Oh, I watched a documentary. Who fucking cares? Is it in evidence? Look at all this shit that's been coming out of the documentaries. Nothing has been presented in evidence. Not a goddamn thing. His divorce? Oh, he's going to get divorced. His wife is going to divorce him. They didn't even say in opening statements that his wife was in a divorce conversation with the family law attorney. Why? Because it's likely not even admissible, much less if it's admissible, they don't know if they're going to admit it. Because what will they actually get out of it? I'm so fucking sick of this charade. I'm goddamn tired of it, Joe. I'm tired of it.
I don't know. I think that.
But you're profiting
ceasefire
every day. That's the thing. I mean, I don't begrudge you profiting off of it. I just sort of don't understand why you're so mad at it, and then you are acknowledging that you're doing it for the grifting. It seems inconsistent.
Of course, I'm doing it for the grifting.
He admits it. That's the difference. The difference is he admits it. His point. This is what
he's so sick of it. That's why he keeps doing it.
Okay. Let me.
Maybe I'm missing it.
You are. The reason what you're missing here is this. It's that what he's basically saying is everyone here knows where Nick Ricada, come from. That I'm doing this whole trial for the grift. I hate this trial. I'm going to provide whatever insight I can. I'm not enjoying this. This is painful, but it's basically how I'm earning my livelihood and taking care of my family. That's why I'm doing what I'm doing. And I'm providing whatever.
No, Joe, no.
See, maybe you didn't get either then, I guess.
I'm watching the show. I'm watching the trial with the people because it's interesting.
Come on! You just screamed that for 3 weeks, Nick. You just screamed that the last 3 weeks have been the most boring period of your life.
So Ricada sounds like. Okay, I'm gonna give away he sounds like me after I get really upset at the children because Nice Mommy has asked 170,000 times. So I lose my mind a little bit and I'm like, would someone please do the daggone dishes instead of putting freaking dirty dishes in the sink? I do not need, more meaning in my life. I have meaning beyond doing dishes. Please put it away. And and then, my son will come up and say, you do not like being a mom? And I was like, no, I love being a mom, but you guys doing the same thing every time is irritating to me. So maybe now I'm most-splaining. So let's let Nick explain.
Joe, this trial should be interesting. It's a double murder trial involving an entrenched South Carolina attorney. It should be interesting.
You
The
can't
state
walk away from this
hasn't
trial
made the
tomorrow.
case.
You can't
The
walk away
state
from
hasn't made the case. Neither has the defense. None of them have brought the narrative. I'm just saying the jury analysis is a waste of time from people who aren't involved in the case.
Right. You're saying that it's purporting to lend insight, but giving us nothing. Is that fair to say? That it comes
fair to
across
say.
as if
I'm
it's trying to
triggered.
give us some perspective, when really it's just people who are just stabbing in the dark. I have no idea, and we'll never know if they're right or wrong.
Yes. They're stabbing in the dark, but people put undue value on this stuff, and it drives me nuts. I hate it.
Oh, he reminds me of okay, so Nick is like my younger son, and he'll go, spaz, 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 and then he's like, I was just upset and tired. And that's why I did that. And you're like, okay, well, I'm glad you can calmly talk about it now, but next time, why don't you just say you're getting upset? And then we can maybe stop something and you don't have to have a spaz out moment.
Well, I don't know. I feel as if I have more perspective after.
No, I feel bad for mentioning it.
Why? That was gold. Are you kidding me? That was we're 3 weeks into this trial. That's the first clippable moment.
That's what I get for checking the gas level with a lit match.
Oh my god.
That was Unabomber level worthy.
I just don't like it because it's this weird thing where people are going to go analyze the jury, but they're not. Their analysis, I hate it. I've said it since depth. I said it in depth, by the way. I don't like the jury analysis. The chat wants it. I bring them on. I don't like it. I would much rather DUI guy and James from court do what they're trained to do. I would much rather get DUI guy's legal analysis on the subject. And I'd much rather get James from court's gallery opinion on the subject. What's the buzz? What's the in and out of court? James from court is wasted as a journalism student on doing jury analysis. He's far better interviewing the people in the gallery. He's far better interviewing the people who are outside the courtroom. The buzz around South.
This is the other thing, is that Nick has really good insights on how to better yourself. I almost paid for one of those, where he just fat shames you as gym motivation. But then I realized that Dr. Now is scarier to me. And yeah.
South Carolina about this. That's what I want to know.
You know what James from court should do? He should do a Project Veritas and ask forensic scientist Megan Fletcher out for a drink.
That's my opinion. I do not like the jury analysis thing. I think it's a waste of time. And I think there's so many, like, I'm not shitting on them being in the courtroom. I think there's a bunch to gather from being in the courtroom.
I love this. I just spent possibly years of my life with hypertension and possibly put my arteries in very real danger of exploding. I was so upset, but I'm not giving you shit, I promise.
I just want their actual expertise, not this pretend thing that developed during DEP. I didn't like it then. I don't like it now.
Well, I guess I'll agree with you that I don't really find much value in the body language people. I don't find any value in it. So I'll agree with you that much.
What is the point? The
Well,
body language people
they admit they need baselines.
They admit it. They admit their analysis is worthless outside of knowing the people. Because of course it is. We've been saying the entire time, when Alec Murdaugh is crying in court, he's sitting there crying. They say, oh, well, we don't know what that crying means. We don't know if he's crying over his family. We don't know if he's crying because he got caught. We don't know if he's crying because of financial crimes. We have no idea. You can only infer something, and the state will always infer it negatively. That's what we know about your reaction in court. And if he had no reaction, it'd be the same way. Oh, he didn't cry when his wife and kid and their brains on the floor were being brought up. It's crazy. So what are we gaining from body language analysis? Now, I haven't seen any in this trial, but what would we gain from that without the person knowing Alec Murdaugh, without them doing a behavioral analysis before he's charged with this stuff and saying, okay, before he acted this way, or looking at interviews from before, what do we gain from that? We gain nothing. And I'm sick of it.
It worked for Runkle.
It worked for Runkle?
I'm saying he went to the death trial and he took his channel from 40,000 subs to 250,000 subs by going to the trial.
Great. It's beautiful for them.
I'm not. It worked for Larry, the DUI guy. He ended up going 250,000 because of it. People feel as if they're. You know what it is. This is what it is. This
trying to tell people that
I'll tell
you.
I'll tell you why you're spitting at windmills here. Okay. It's because people who care feel emotionally invested in something. They want to have the facade of feeling like they have more information than they can accept.
I thought I was tilting at windmills in Don Quixote, but I could be wrong.
On their own. So they feel as if these people are providing that perspective that they cannot otherwise get, even though you are ultimately correct that it's all just blind stabs in the dark when no one actually knows what the hell they're talking about. But since they're able to sell that as if they have, because they have a unique perspective of what the jury is looking at and thinking, so it gives this image, this facade that, oh wow, now we have a feel for the jury, even though you are ultimately correct that it's a mirage. You can't, unless someone there is a mind reader, there's no way for them to know what the hell any of the jurors are actually thinking. You're correct. You're right.
That's what I said, but louder.
Right, but that's why. But that, I was explaining to you why people actually still crave it. It's because people crave that facade of feeling as if they have more perspective, even if it's empty perspective. That's just my thought on it.
Oh, okay. Sorry, Nicole. Well, that was hilarious, and thank you, Lefty, for gosh, the word escapes me. Recommending that. I am going to hop off of here and make some macaroni because the boys can make their own. Yeah, suggesting, when you feel like you're semi-smart, but then the words you want to use are not there in your brain, and you're like, well, there's a word there, and it was something. But I will jump off of here. I will keep paying attention to both Discord and Twitter. I have the verdict watch on here. If anyone has different people that are, in the court, like hair helmet, and he says that there's a question or something, please let me know, and I will be back when we get maybe either a question or the verdict. It's my first time waiting for a verdict on my own trial. I'm all irritated. I will see you guys later. Have a good Friday. If we don't get anything until Monday, have a great, safe, fun weekend. And I will see you Monday to start Verdict Watch again. Bye, guys.